Good morning, everybody. My name is Debbie. Welcome to my channel. I'm sorry about the Phil Spector trial this morning, guys, but we missed something yesterday in the Karen Reed trial. I need to wait. I need to wait. I need to wait. Court TV, this is the second time this has happened. When I thought they were done, but they were not. So even when Court TV puts up their little, we're done thing that they put up, I need to wait. Good morning, you guys. I just realized something. I am much more in frame now. I have a built-in webcam. So if I tilt the screen down, you can see me better. And you'll be able to see Shadow better too. Duh. So fix that problem. So good morning, everybody. Hey, Nancy, Jill, I see that you're on the road again, sweetie. Judy, of course. Let's see what Judy has for us this morning. Bob Alessi. Alessi is a god among lawyers. Let me tell you, that man. I loved the team before. I adore the team now. Alessi is just the perfect addition to this team. Yesterday, Peter said, I wonder if Alessi has some kind of medical background. Oh, yes, he does. He was a pharmacist. And let me tell you, I think pharmacists have to have even more school than doctors. Don't quote me on that because I'm not 100% positive. But my cousin went to pharmacy school. It's like, I'm not sure, but it's a lot. It's years and years and years. It's a lot. Bob Alessi has a BS, Albany College of Pharmacy and Health Sciences, New York State Judicial Institute. He also taught at Albany Law School for 5 years as an adjunct professor of law. Wow. So yeah, he has a medical background. Robert is a licensed New York State pharmacist and Eagle Scout. Bar admission, New York Court, Supreme Court of the U.S. Court of Appeals for Second Circuit, U.S. Court of Appeals for the D.C. Circuit. Yeah, I thought he was an appellate lawyer. And then somebody was like, no, he's not. So I was like, wait a minute, why did I hear it? So he is. He's a regular lawyer and an appellate lawyer and a pharmacist. And it's so impressive to me. Like, I was just a nurse. It's so impressive to me when people are proficient in one career and then go to another career and are proficient in that. I mean, like, it's a little intimidating too, because I'm like, what have I done with my life? But okay, so hey, Carla. Hey, Terry. Okay, so there was a hearing at the end of the day yesterday that we missed, and Alessi is pissed. It has something to do with the ARCA witnesses. Again, Brennan is still raising a stink about them. And Whiffen, which was Brennan's witness, and Shannon Burgess, which is Brennan's witness, and Welcher? Is it Welcher, Judy? Which is Brennan's witness. There's a time they're calling it a trigger, and it's just seconds different. I don't fully understand it. I watched EDB. I didn't get to watch the whole thing. I watched Emily D. Baker and Peter Tragos, and they both say this is a huge deal and Bev has to allow this. They could ask for a mistrial, but they're not. But they are saying either, hey, Carla, either for a continuance or to exclude Brennan's expert witness, because apparently, remember the whole thing about the deadline of the ARCA witnesses, like Brennan was saying, well, no, we're being ambushed. We need this information now. We didn't get it in time. So since we didn't get it in time, that they should exclude the ARCA witnesses. Well, basically what's happened is his expert has changed the time of the impact by seconds. And because of that, now it's going to throw the ARCA witnesses testing or whatever off. So Alessi's pissed because now I guess their calculations or whatever are skewed a bit because of just the seconds that's off. So Alessi can't even tell Bev how long of a continuance they would need to fix this thing until he talks to the ARCA guys, which he was going to do that and then get back to her this morning. So we need to watch what happened because they're going to talk about this when court convenes this morning. So
not note any hair now.
Oh, Debbie, I had it all queued up and then I again pushed the wrong button. No, I didn't push the wrong button. I pushed the bar as I was pushing play.
Discuss this case.
She's like, she replies to the jury right now. Well, I guess she didn't lie. I didn't know that. She's like, we're on schedule, and now they might have to have a continuance.
You may be seated.
So I guess she didn't technically lie.
All right, so Mr. Alessi, I'll hear you. I'll hear you, Mr. Alessi.
Thank you, Your Honor. The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welter, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes.
Okay.
My understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay.
So the Commonwealth has established in reports right up until not established, they had stated in the reports of Aperture, particularly the slide presentation of Dr. Welcher, a trigger called 1162.2 that they had associated in the report of Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12/31/38 to 12/31/43. And we have been assuming that information, and this is from best memory, but I believe it's slide 137 or so, where this statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. I'm just going to get. So, although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And Your Honor may recall that the seconds, literally seconds matter in the analysis of many factors. I won't go into them other than to say, I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally by seconds determinative in some ways of various analyses. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 12/31. We received information that has changed that. Now, Your Honor, that is a Rule 14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA, it's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffen's analysis. And Mr. Whiffen's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture. And we are in a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it. And so, Your Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation, remedy be that this is not allowed, and that the Commonwealth proceed with its, the information of Aperture that has been extant before the May 8th date of the report. Thank you.
All right. Do you have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ACA or have them go by their old report, right?
Right. And Your Honor, I'm going to answer your question, but with just the quick point that this is really much different than ARCA because two reasons. We are the defense, and ARCA is a rebuttal to the prosecution's case. That is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you
Right.
have
So-
another
so-
option.
It's not what I am saying that I am proffering. I think the only remedy here is exclusion and a Rule 14 violation.
And you're not waiving that.
I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, a continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't, given what's been going on, I haven't even had a
Right.
chance to talk to ARCA at
All
all.
right, so tomorrow morning, let me know that. All right,
And Your Honor, I will do that, of course. And I will also say, without getting into an elaboration of it, we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffen, I had my whole cross-examination, not whole, but a significant part of my cross-examination of Mr. Whiffen based upon going through human volitional conduct off that phone that was after that 1162 trigger. And a lot of our defense in theory is based upon that's been in existence now for several months. And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor's question.
all right, thank you. Mr. Brennan.
Your Honor, this disclosure is not a Rule 14 violation. The Commonwealth, just like the defense, is entitled, continues to work on their case and study their case as time goes on. This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. If you recall, in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time, given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as a witness they may potentially call. Mr. DeSorga wrote a report, and in the report, he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the text stream data, or the black box data from the car, has an event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times. We asked our expert to review their expert's report to see if he was accurate that the variance means that these times would never align. And that's what he did. He studied the data, he studied the waves, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned from his opinion is that Mr. DeSorga was wrong. He used information from different phones, not recognizing the items that these timelines came from and that his time estimates are wrong. So then he looked at the time of the event of the ignition on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that 7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moment when Mr. O'Keefe last had user interaction, and that reconciles with the data. It does not change the text screen data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over on May 8th. There was no delay. It's been a week now. The defense has had this information. And so this is not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong by the defense expert, and it is clarified and it is favorable for us. And so we should be able to use it.
Did you intend to use it in your case in chief, or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
My case in chief, because we now have this available data. As I said, this wasn't ambush, isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
Okay. Yes.
I'll do it quickly.
Okay.
Attorney Brennan has provided a lot of information, and he has accurately provided information, but he's got the time completely wrong and the significance respectfully completely wrong. I'm going to hit his 4 categories quickly. He said, he referenced Mr. DeSorbo, who is a defense witness. Two points about Mr. DeSorbo. First, Mr. DeSorbo provided his expert report within the reciprocal discovery deadline.
Okay.
And he provided that report months ago.
Okay.
So as I heard Attorney Brennan, he's saying the reason why we're getting something on May 8th is because Mr. Burgess supposedly is responding to that. That was months ago.
Okay.
The more apt point is, or an even more apt point is, Mr. DeSorbo was responding to the information of Aperture. It wasn't like Mr. DeSorbo was coming up. He was rebutting as defendants do. So, and it's Mr. DeSogra, D-I-S-O-G-R-A. Again, D-I-S-O-G-R-A. So that's an important point with regard to Mr. DeSogra. Now I want to go to Attorney Brennan's comment about clocks are different. I agree with Attorney Brennan on that. The shortcoming for Attorney Brennan's argument, however, is that the clocks are different concept has been in existence in this case.
EDB was like, no, Alessi, it is not time drift. It is wibbly wobbly, timey wimey. Which I loved, but I don't think he could get away with that in court.
For over 6 months. I can give you by memory Mr. Whiffin's report of December of 2024, where his report went into the different clocks and what their significance was. So that is almost 6 months ago, at least 5 months ago, the issue of different clocks has been in existence in this case. So therefore, the issue of different clocks dates back to then. But even more fatal for the Commonwealth's argument is that Mr. Burgess himself issued his report and talked about the difference in clocks. He already knew it. He already had it.
Did he testify to that last time? Did he testify?
Aperture was not part of the first
All
trial.
right, I thought Burgess was, no?
No, neither,
Okay.
no one from Aperture was.
Yeah, I knew
Your Honor.
Aperture was, and I thought he may have been something. The name just sounded.
Neither
familiar.
Burgess nor Welcher were
Okay.
part of the first trial, but they were retained. Aperture was retained, I believe, in October of 2024.
Okay.
And at best for the Commonwealth, Aperture had, and Mr. Burgess and Dr. Welcher had Mr. Whiffin's report that talked about the clock differences. So the clock differences cannot be, as the Commonwealth is proffering, some sort of new information that caused Aperture to provide a new report. This variance that Attorney Brennan talked about, it's called the clock drift. A more layperson's term is a variance of time. Mr. Burgess, in his original report months ago, has a whole section on clock drift. That's not a new concept for him. He's just changing the drift.
Okay. So what I'd like to do, because I want to address the other issue and I don't want to keep people here too long, can you wrap it up, Mr. Alessi, or is that?
In 60 seconds.
Okay.
Thank you, Your Honor. Your Honor, the last point I wanted to make, and I think I heard Attorney Brennan correctly, is he said he was surprised that he got this report dated May 8th. That's what I heard. So if the Commonwealth is surprised that they got it, that should mean, to me, Your Honor, be an outstanding fetching reason to not allow it, because they're surprised to get it. And I can lastly say this, Your Honor, there's nobody that's more surprised to getting this than the defendant when we got it on May 11th.
Okay. Thank you. The other issue about calling your expert on rebuttal, Mr. Brennan, based on the late disclosure of the ARCA materials. What's your argument on that?
I won't iterate the entire past, but Your Honor has found discovery violations. Your Honor has found that I want to phrase this properly, efforts of the defense were improper. And inevitably, we've now received an extraordinary amount of discovery on the most important issue in this case, well beyond lines, without any excuse. And the court, understandably, has overruled the government's objection and has stated that it is going to allow the defense to proffer two expert witnesses in a very complicated field, in an issue that is the heart of this case. If you're going to allow them to testify, despite the fact that we have not had adequate time to review and to prepare and to address it, the Commonwealth has the burden of proof. The Commonwealth has an obligation to prove its case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr. Welcher. As you know, he was away. He did not get a report until maybe May 7th. He did not have a chance to look at it until May 9th. An extraordinary amount of work, effort, and expense has gone into preparing our case for the jury. He is still in the process of reviewing the materials. There are entirely new subject areas within this information, well beyond the simple four opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review, but an analysis, testing, vetting, and then preparing testimony to address the claims made by the defense experts. Not to get into a battle of disparagement, but our expert has found extraordinary issues in his first reviews of material. And some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate the failures of these ARPA witnesses. That's going to take time. You've heard from the ARPA witnesses themselves. With the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadline violations. They were given 5 weeks. We did not get the report until May 7th. And so we believe we are entitled to have our expert review all the materials, do his testing, provide opinions. None of that is going to happen anytime soon because he still has not finished reviewing all the materials. There's many, many gigabytes. He is in a difficult schedule. He is away tomorrow, Saturday. We were going to try to begin to prep at the end of the weekend. There is no way he's going to be able to testify anytime soon and have all of this validation and vetting and testing.
So what is it exactly you're proposing?
So what would we like to do is have him testify about what he has prepared, that he's had adequate time to prepare. If either of these ARPA witnesses testify and they introduce new opinions, new testing, new demonstrations, he should be able to continue reviewing the materials, actively engage his own testing now. So by the time the defense case is over, he will be prepared to come back and address the new issues, not the older issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders, and so that he can then address the jury on those specific new issues. I see no other way of this expert fairly being provided, presented to the jury. The unfair prejudice cannot be cured in any other way. We ask that he be able to continue his review, offer rebuttal opinions on anything that is new and not to encroach on anything that's been previously provided.
Can Burgess testify after Welcher?
No, because Dr. Welcher relies on Shannon Burgess's information material. It will make no sense. I thought about it. It makes no sense to the jury, this presentation, unless Shannon Burgess has an opportunity to provide the background information.
Right. Mr. Lassie, I'll hear you on this.
Thank you, Your Honor. I think and I understand that it's very well understand the time of the day, so I'm going to do this hopefully efficiently. When we're talking about ARPA and the information of ARPA, it's very important analytically to put them in their two proper buckets. The first bucket is the information and opinions of ARPA that have been in existence since February of 2024.
Yeah, let's focus on the beyond. Let's focus on
Okay, good, because my pithy conclusion is there should be no prejudice on that.
And I don't think the Commonwealth's even suggesting that.
So if we're focusing just on the quote new information bucket, Your Honor, it's very important to understand that what ARPA is doing is in response to the testing of Aperture. ARPA did not come up with new approaches. We, again, to state the obvious, are the defense. We get to rebut what the prosecution has put forward. And so what ARPA has done with the new information, new testing, is simply to rebut what Aperture has done. So I do not understand the length of time or the lift, if you will, that's being proffered for Aperture. Now with regard to the time period, Your Honor has already determined what the appropriate approach is for the new information from ARPA. When Dr. Rentschler was on the stand, and with Dr. What you said, when can you get me the information? And they said, I think it's May 6th or May 7th, whatever, and they met the deadline. They did it. We proceeded along with the trial with that information. We complied with that request to continually try to claim that there should be ongoing remedies of something that's already been decided, I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going to continue to address this matter as if the defense is making perpetual violations. There was a determination made, and then the question was the remedy. So I'm just addressing the Commonwealth, positing that somehow there's continuing violations. My final 2 points. What Mr. Brennan is seeking is improper. What it's seeking is the most extraordinary situation, which is have Aperture come before the jury, testify to certain things, have ARCA have to come on, and then have Aperture come back and essentially have almost a rebuttal to a rebuttal as of right. I do not understand that process. I do not understand that proposal. It inverts the order of proof. It prejudices the defendant because it almost ipso facto gives a double re-rebuttal, sur-rebuttal to the defense. I believe, Your Honor, the final point is if Your Honor is inclined to give Aperture more time, and I haven't even heard a deadline yet for Dr. Welcher. It's still open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when Aperture can conclude its review of the ARCA work, and that there be a reflection that keeps the order, namely that the prosecution comes in with Aperture, Dr. Welcher, and Mr. Burgess, and then the defense, as part of its case in chief, puts on ARCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's almost a self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And Your Honor, I just think that's improper and prejudicial. There's another, and importantly, it's a burden shifting to the defense.
All right, so I have a question for you, Mr. Lessie. Are you still thinking that if it's on a defense that will take roughly a week and a half for that to take place?
That is our best estimate still, Your Honor.
And not holding you to this because obviously you have no burden. If ARCA is part of that defense, when in that week and a half time frame would that be?
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay. All right. I needed all this information now, so I appreciate it. All right. Thank you.
Court, all rise.
Goodbye.
Okay, that was what we missed. Now, let me see. What time is it? 9:10. Let's see if they're in the courtroom and what's going on. So they should have had more of this morning before the jury came in, because Alessi said he would get with the ARCA guys. What Brennan wants to do is have this back and forth as information comes in from the experts, and that's not how you do it. No, absolutely not. That is not how you do things. And Judge Canoni should not, under any circumstances, allow that to happen. Can you imagine if it was like Commonwealth experts, defense experts, Commonwealth experts, defense expert? It would be hell. Like, seriously. We would be here for months and it would get so boring and so tedious. It would be miserable. And, and the time it was done, the jurors would just be like, I just want to go home. Forget fair and impartial. They'd just be like, whatever, I don't care anymore. StreamYard, why aren't you sharing my screen? Where is that coming from? StreamYard, you're getting on my last nerve. They're at sidebar. Nothing to see. There we go. Okay. I know, right, Jill? I love that Alessi used his own words, though, to come back at him. You know, I don't like the paper clip. Be cute. My ambush. This is an ambush. I don't feel so too terribly bad anymore because EDB's StreamYard crashed on her yesterday. And she's like the GOAT, right? So I was starting to get a complex. I was like, it crashes on me. I'm this little baby YouTuber and I can't stop it from crashing. Everybody else can have theirs do everything. I mean, he's like, yeah, she's gonna try to make her own street thing. Okay, how come Nancy, you say that every time like you're surprised. Jill broke it. It's always Jill. It always does it when Jill comes in the chat. It's Jill's fault. I have to take this whole thing out now. Out. But I didn't have enough to finish the whole head anyway. So I have to go buy more yarn tomorrow. So it doesn't really matter. The chances of me finding the exact same color are, I probably could have, but easier. And I keep forgetting to do it. When you buy a skein of yarn, take a picture of the label with your phone, and it will have like the brand, the color, the lot number, everything. So then when you go back to buy more, you've got all that on your phone, and then to get the same color and maybe sometimes even the same lot number. Because sometimes it can be the same color, same brand, same everything, but it's a little bit of a difference. Oh, Jill, you know you didn't break it. I have to put Frodo together, but this one, this pattern, I lost the doll eye. Great. Now one of the dogs is going to find it and chew it up. Oh well. I got a lot of doll eyes. This pattern calls to glue the hair on, and I've always sewn the hair on because sometimes I sew it on and get it on crook and have to pick out. It's easier to unsew something. I don't think if I glue it on there, I can get it back off. If it's crooked. So I'm kind of leery, but he's got a lot of hair. Where does hair go? He's got a lot of hair. He's got like 2 layers of hair. I could sew it, but it would take me an hour to sew it. I don't know, it might take me an hour to glue it. That's a lot of hair. But then sew it wrong or crooked, I can just snip the stitches and redo it. But if I glue it, it's there.
Yea, yea, yea. All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning again, council. Good morning again, Ms. Reed. Good morning, jurors. So I appreciate your patience. I have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone said yes or nodded affirmatively. Were you also able to follow my instructions and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this
Well, I
case?
guess
since we
they're not
left
going to
yesterday?
argue it.
I have one other important
did
instruction
it.
for you folks, and
Hang on, let me.
it's so important.
Maybe that's what they were doing at sidebar. Okay, wait. Okay, maybe that's what they were doing at sidebar.
Important that each and every juror can hear the evidence or the testimony that's presented, can follow the testimony, and can understand and evaluate the testimony of each witness and the exhibits. In order to do that, I just want to be very clear that it's important that people do not comment on the evidence or make any comments. Once you enter the room, it's probably a good idea to just listen. Don't talk, don't make any facial expressions, no muttering under your breath, no audible noises, because people need to hear. For your fellow jurors, I would ask that you be very careful to make sure you don't do that, and out of respect to the lawyers who worked so hard to get this case before. Okay, thank you very much. With that, Mr. Brennan, your first witness, please.
Or if I could begin by offering a stipulation that's agreed to between the parties.
Okay, can we turn the AC down, please?
Nancy, can we read?
Yes.
Your Honor, if I may, I'd like to read a stipulation agreement between the Commonwealth and the defense.
Okay.
And the stipulation between the parties is as follows. Now comes the Commonwealth and Karen Reed, the defendant in the above captioned matter. Both parties respectfully stipulate to the following. The two Massachusetts State Police troopers present at the autopsy conducted by the medical examiner, Dr. Scortibello, on January 31st, 2022, were Trooper Keefe and Trooper Watson. Former Trooper Michael Proctor was not present.
Thank you.
And
Yes, thank you.
with that, Your Honor, I'd like to introduce and play clip number 21.
Okay, Paul, turn the AC off. Hold on 1 second, please. I just want that. Can the jurors hear better with that on?
So John's laying there, his left and his right, and I approached John from the left. That's where the street is. And like perched on his nose, like just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face.
So we need this marked.
Yes. We have the item.
169.
Mr. Lally, your next one.
Your Honor, the Commonwealth calls Andre Porto to the stand.
You solemnly swear the evidence given to the court and jury in the case now hearing to be the truth, the whole truth, and nothing but the truth. So help you God.
Morning. Hey, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
Yeah, my name is Andre Porto, last name spelled Porto.
And what do you do for work, sir?
I'm a forensic student in the DNA unit at the Massachusetts State.
And where did you go to school?
I received my undergraduate Bachelor of Science in Microbiology from the University of Massachusetts in Amherst. And then I received a Master of Science in Biomedical Forensic Sciences at the Boston University School of Medicine.
Now, following your education, where did you go to work?
I started at the Massachusetts State Police Crime Lab in the DNA unit.
And how long have you worked at the state lab?
Oh, yeah, sorry.
How long have you worked at the state lab, sir?
Since September 2019.
Now, when you joined the lab, what was your position and title that you were initially hired for?
I was hired as a forensic scientist 1.
Now, can you please explain to the jury your duties and responsibilities as a forensic scientist 1?
Hired, and we undergo an extensive training program where we do undergo the analysis process in training casework samples, where we learn how to do the lab work and analyze profiles. And at the end of this training, I took a competency test to make sure that I was able to accurately conduct the DNA analysis process. And once I passed that, I was then put on to do casework. And a year after completing both my competency tests and a year after my hire date, I was then promoted to a forensic scientist 2.
And so you're currently a forensic scientist 2, is that correct?
Correct.
Now, so what type of analysis do you currently do at the Massachusetts State Police Crime Laboratory?
I can do the DNA analysis process in casework and known samples. That includes the lab work as well as analyzing the DNA profiles that are generated from the work.
Now, first, just in general terms, but specifically with reference to DNA analysis, can you explain to the jury how is that analysis performed?
Sure. So there's 4 steps in the analysis process. The first step is extraction, where we apply heat and chemicals to the samples to break open the cells and release that DNA to be available for use. Step 2 is called quantitation, where we take a small sample of that extracted DNA to estimate, and we use chemicals and run it through an instrument to estimate how much DNA we extracted. And then we proceed to step 3, which is called amplification. And that's basically, think of it as a molecular photocopier, where we target specific areas of the DNA to make millions of copies of it. And then we run it through, go to detection, where we run it through an instrument, and we generate the DNA profile as an electronic file on a computer.
Now, is the state lab where you work accredited?
Yes, it is.
And by whom?
We are accredited by an organization called ANAB, which stands for ANSI National Accreditation Board, and ANSI stands for American National Standards Institute.
I need you to slow down, please.
Sorry.
Please.
Sorry.
Now, Mr. Porto, are there steps taken in your lab during that process that you were just explaining to prevent against contamination?
Yes, there are.
And can you explain what those are?
Coordination between analysts would be to bleach and wipe down the workstations before use and after. Another way to prevent DNA transfer from analysts to the samples is to wear personal protective equipment, such as lab coats, gloves, masks, hairnets, and beard guards. And a way to prevent transfer from sample to sample would be to frequently change gloves, as well as only have one sample open at a time.
Now, with your work at the lab, is there a review process that your work undergoes?
Yes, there is.
And can you describe that process to the jury?
Sure. So once I complete my work, the file undergoes 2 types of reviews. The first is a technical review, where another qualified analyst will take the file and they'll do their own independent assessment and make sure that they come up with the conclusions and that they agree with the conclusions that I reached. And they'll also make sure that all the protocols were followed and every decision is scientifically sound. Once that review is completed, it undergoes an administrative review, where another qualified analyst will then look through the file and they look for clerical errors, such as typos or missing page numbers or missing case numbers. Once those 2 reviews are completed, the results can then be reported out.
Now, as a part of that accreditation process that you were speaking about a few moments ago, do you undergo anything called proficiency testing?
Yes, I do.
And can you explain to the jury what that proficiency testing process consists of?
Yeah, so a proficiency test is a test that's administered twice a year by an external vendor. And the results of this test are not known to the analyst at the time. And we basically treat it like it's a real case, where it undergoes the analysis process as if it were a real case. And this test is used to show that the analyst is demonstrates ongoing competency in the DNA analysis process. and successful completion of the test is required to maintain qualification as an analyst.
And what areas do you specifically undergo proficiency testing in?
DNA analysis.
And have you successfully completed each of those proficiency tests that you've taken?
Yes.
Now, Mr. Porto, could you explain to the jury what exactly is DNA?
Yeah, so DNA stands for deoxyribonucleic acid, and it's basically the building block that makes us who we are. We each have 2 copies of our DNA, one that we inherit from mom and one that we inherit from dad. And that this combination makes sure that, barring with the exception of identical twins, we all have different DNA.
And is DNA the same in every cell of a person's body?
Yes. So what that means is, if I were to take a blood sample and a saliva sample from the same person, the same DNA profile will be generated.
Now, you spoke a bit earlier about the different steps included in the DNA testing. If you could, just a little bit slower, go through each of those 4 steps again for the jury.
Sure. So like I said, it's a 4-step process. So extraction, quantitation, amplification, and detection. So extraction, we use chemicals and heat to burst open the cells to make that DNA available for use. Quantitation, step 2, we take a small sample of that extracted DNA. We use a different set of chemicals and an instrument to estimate how much DNA is available for use. Amplification is the 3rd step, which I mentioned is the basically molecular photocopier, where it makes millions of copies of specific areas of the DNA. And then the 4th and last step is detection, where we run those amplified copies through an instrument, and we generate the DNA profile as an electronic file on the computer.
Now, Mr. Porto, what is STR?
So STR stands for short tandem repeats, and they're the locations that we're making the millions of copies of.
Now, in your work at the lab, do you have something that's referred to as a known item?
Yes.
And can you explain to the jury what a known item is?
Sure. So a known item is an item that's taken directly from a person to be used as a reference sample, so we know what the profile is.
And conversely, what is a questioned item?
A questioned item is an item that's taken, let's say, from a crime scene where we don't know what the source is.
Now, do you also have terminology within your lab as far as a parent versus a child item?
Yes, we do.
And can you explain how those labels are and how they reference to what you do in your work?
Sure. So a parent item is, for example, the original item, and the child is a sample of that item. So for example, this box of tissues would be the parent item, and if you were to swab the outside, the swab would be the child item. So the box of tissues would receive, let's say, an item of 1-1. The swabbing of the outside would receive an item of 1-1.1.
Now, what are positive and negative controls?
Yeah, so a positive control is a control that has it's a known sample with a known DNA profile that we use in every step of the DNA analysis process to make sure that each step and instrument worked as expected and properly. And then a negative control is a sample that has no DNA in it. It only receives the chemicals that we use, and that's to ensure that the chemicals that we're using don't have any DNA inherent to them.
Now, when you as an analyst or forensic scientist too are assigned work within the DNA unit, where do you retrieve that evidence from?
Yeah, so I retrieve it from a locked cold room that's only accessible via keycard.
Now, why are items kept in cold storage?
Yeah, the cold storage helps preserve the DNA for long-term storage.
And as far as the heat versus the cold, why is it that it's specifically kept, or why does the coldness of the storage room help preserve the item?
The cold can help prevent, let's say, growth of bacteria and mold that can degrade DNA.
And what does heat do conversely in reference to an item of forensic value?
Heat can help degrade DNA, and also promotes bacterial and mold growth that can further degrade that DNA.
Now, when you receive an item from the cold storage, how is that item typically packaged when you retrieve it from there?
Sure. So the item comes in these plastic, clear, transparent plastic sealed containers that has a label with a case number on it. And inside of that, each sample is within like a small plastic tube that has a label with a case number and item number.
Now, at some point, were you assigned to perform some work on a lab case number 22-02184 pertaining to this defendant, Karen Reed?
Yes, I did.
And what type of work in general terms were you assigned to do in this case?
I was assigned to do the DNA analysis process.
And that was on several items, is that correct?
Correct.
And could you explain to the jury the sort of the process that you used to analyze evidence in this case?
Sure. So the case underwent the 4 steps that I explained before. So extraction, quantitation, amplification, and detection.
And there was a known standard that was done in this case, specifically in item number 8-1.1.1. Is that correct?
Correct.
And did another analyst test and report the results from the known blood standard from that item 8-1.1.1?
Correct.
And how is that done?
Yeah, so that undergoes the same process that I explained. It'll go through the 4 steps: extraction, quantitation, amplification, detection. And then the analysts that did the interpretation and reported that out, the known standard out, they went through the profile to make sure that it's one person or single source. And once that went through the review process that I explained, so technical and administrative review, and once that was all completed, the standard was available to be used for comparisons.
And to whom was that known standard identified as belonging to?
John O'Keefe.
Now, you use the word in there as far as a single source. Can you explain to the jury what your understanding of that term is based on your training and experience?
Sure. So a single source is just a DNA profile that has one contributor to it. So only one person contributed DNA to that profile.
What exactly is a DNA profile?
Yeah, so a DNA profile is basically the combination of all of the locations that we amplified during the 3rd step of the process. And it's basically, you can think of it as like a chart, like an EKG, where it has peaks and valleys, and each peak has a specific number, and the DNA profile is just a combination of all those numbers put together.
Now, can you explain to the jury in general terms, to start with, the process of comparison between a known standard and a questioned or unknown standard?
Sure. So first, I did the analysis on the question items. I did the 4 steps. I analyzed the profiles that were generated. I then interpreted, make sure that I could determine the number of contributors. And once that was completed, I then used the standard that was available and compared them to all the profiles that were suitable for comparison.
Now, sir, starting with item 3-1.1, what was that a sample from?
That was a sample from taillight passenger.
And from a specific vehicle, is that correct?
Correct.
And what, if any, information were you given as to that vehicle that the swab from the taillight was from?
Do you mean like the license plate?
Yes.
Could I refer to my notes?
Yes.
Thank you.
Your Honor, with the court's permission, this is a little detail as far as the testimony
I
goes.
don't have a problem. Does the defense object?
I do not.
Okay, thank you.
Thank you, Your Honor.
So the license plate was 3G6684. Right, I'm sorry, 3GC684.
Now, with reference to the swab from the taillight, were you able to generate a DNA profile from that item?
I was.
And from your comparative analysis from that question item to that of the known standard of John O'Keefe, what did you conclude?
So the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. And the DNA profile from this item is at least, so sorry. I'll just restart. So the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. And the DNA profile from this item is at least 510 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, what does that mean?
So an inclusion is basically when I look at the question DNA profile that was generated, and I compare it to the known DNA profile. And if the characteristics of the known profile are consistent with the characteristics observed in the question DNA profile, that's an inclusion.
Now, as far as that number, 510 non-alien, how many zeros in that number?
So a non-alien is a 1 followed by 30 zeros.
Now, that profile, in addition to Mr. O'Keefe's profile, also had 2 unknown contributors, correct?
Correct.
Now, was that item also submitted to an outside vendor named Bodhi Technologies for further analysis?
Correct.
And with reference to your comparative analysis from the profile from this item to Mr. O'Keefe profile, if you could again just expound upon what does inclusion mean?
Yeah, so an inclusion, I compared the known standard that I had available for use from John O'Keefe to the DNA profile generated from the tail light. And the DNA profile was, if that was consistent with the DNA profile that I observed in the questioned item, and that's what an inclusion means.
Now, regarding item 3-6, what is the description of that item?
Yeah, so 3-6 is a root end of hair from exterior passenger side rear panel.
And is that the same vehicle as far as the taillight sample?
Correct.
Now, with respect to hair in general, there's a root end and a shaft end, correct?
Correct.
And what limitations does your lab have with regard to DNA testing of hair?
So when we test hair, we're actually, the root end of the hair, we're looking at any potential skin cells that might be attached to the root end. So that's where the DNA that we're looking for is coming from. And if there's not too many, yeah.
Now, are you familiar with the term based on your training experience known as autosomal DNA?
Yes.
And can you describe for the jury what your understanding of that term is?
Yeah, so autosomal DNA is DNA that's located in the nucleus of the cell, and that's the DNA that we inherit from both mom and dad.
Now, are you also familiar, based on your training experience, with a term known as mitochondrial DNA?
Yes.
And can you please explain to the jury what your understanding of the term mitochondrial DNA is?
Yeah, so mitochondrial DNA is DNA that's found in the mitochondria of a cell, and we inherit that from the mother.
It may be somewhat evident, but could you please explain to the jury sort of the difference between autosomal DNA on the one hand and mitochondrial DNA on the other?
Yeah, so like I said, the autosomal DNA is the one that we have two copies of, where we inherit one from mom and one from dad. And then the mitochondrial DNA is a circular DNA that we just inherit from mom.
Now, is the Massachusetts State Police Crime Lab equipped to perform mitochondrial DNA testing?
No, we're not.
Now, was the DNA extract from the hair also sent to that external vendor, Bodie Technologies in Lorton, Virginia?
I'm not sure if the extract was sent, but I know that the shaft of the hair was sent to Bodie.
Now, what testing did you perform on the hair?
I did the regular DNA analysis process on the root end of the hair.
And that was done prior to it being shipped to that external vendor, is that correct?
Correct.
And what conclusions were you able to draw from the testing that you did on the hair?
Yeah, so there was no human DNA detected, and STR analysis was not performed.
Now, what does that mean, sir?
Yeah, so it means that I didn't detect any human DNA. So there might be DNA on there, but it was below what our instrumentation could detect.
Now, turning our attention to item 3-2.1.1, what is the description related to that item, sir?
It's a sample from the exterior of broken drinking glass.
And is there any further indication as far as the broken drinking glass, as far as where it was recovered?
Oh, yeah, 34 Fairview Road.
And were you able to generate a DNA profile from this item, the drinking glass?
Yes, I was.
And from your comparative analysis from this question item to that of the known standard of John O'Keefe, what did you conclude?
Yeah, so the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 530 non-million times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown unrelated individuals. This supports an inclusion.
This is the last time I'll ask you this, but just if you could reiterate to the jury, what does an inclusion mean?
Yep, so an inclusion is when I compared the known standard to the question item, and if the profile in the known standard is consistent with the profile in the question profile, that's an inclusion.
And that number again, as far as 530 non-alien, how many zeros again in that number?
That's a 1 followed by 30 zeros.
Now, sir, if I could turn your attention to another item, 7-1.2.1, what is the description related to that item?
Sample from stain A on upper right leg of jeans.
And is there any further indication as to whom those genes belong
to? John O'Keefe.
Now, were you also able to generate a DNA profile from this item, the stain A on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from the question item to that of the known standard of John O'Keefe, what did you conclude with reference to that item?
The DNA profile was interpreted as a mixture of 3 contributors, including male DNA. Contributor 1 is suitable for comparison, and due to limited information, contributors 2 and 3 are not suitable for comparison. The DNA profile from this item is at least 570 non-million times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Thank you, sir. Now turning your attention to item 7-1.3.1, what is the description related to that item?
Sample from stain B on upper right leg of jeans.
And same genes as the previous item?
Yes.
Now, were you able to generate a DNA profile from this item, stain B, on the upper right leg of the jeans of Mr. O'Keefe?
Yes, I was.
And from your comparative analysis from this questioned item to that of the known standard of John O'Keefe, what did you conclude?
Yep, so the DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 660 non-alien times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, with reference to item 7-1.4.1, and again, these items with the dash and the point, is that what you were referring to earlier as the parent-child relationship between items?
Yes.
And what is the description for 7-1.4.1?
Sample from stain C on upper right leg of jeans.
Now, were you able to generate a DNA profile from this item from stain C on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis of this question item, stain C, to that of the known standard of John O'Keefe, what did you conclude?
The DNA profile is a mixture of at least 2 contributors, including male DNA. Contributor 1 is suitable for comparison due to limited information.
I wonder who the unknown contributors are. I wonder if the police had tested some of the people in the house whose lawn he died on. I wonder if they would have been a match.
Contributor 2 is not suitable for comparison. The DNA profile was interpreted as a mixture of 2 contributors. The DNA profile from this item is at least 830 non-million times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, with reference to item 7-1.5.1, what was the description of that?
Sample from stain D on upper right leg of jeans.
Now, were you able to generate a DNA profile from this item from stain D on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from this item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 3 contributors, including male DNA. The DNA profile from this item is at least 670 non-million times more likely if it originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals. This for an inclusion.
Now, sir, did you do some testing on an item 7-1.6.1?
Yes, I did.
And what was the description associated with that item?
Sample from stain E on upper right leg of jeans.
And were you able to generate a DNA profile from that item, stain E, on the upper right leg of Mr. O'Keefe's jeans?
Yes, I was.
And from your comparative analysis from that question item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 2 contributors, including male DNA. Contributor 1 is suitable for comparison. Due to limited information, contributor 2 is not suitable for comparison. The DNA profile from this item is at least 1.0 decillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides a support for an inclusion.
I used a different number there as far as a decillion. How many zeros is a decillion?
Yeah, a decillion is a 1 followed by 33 zeros.
Decillion? That's
now,
more.
With each of those items that you just testified about as far as the genes, the question items from the stains on Mr. O'Keefe's jeans, those were each located on the right leg, correct?
Correct.
Now, did you also perform some analysis on item 7-1.7.1?
I did.
And what is the description associated with that item?
Sample from unstained areas of the exterior of jeans.
Now, were you able to generate a DNA from the unstained areas of the exterior of Mr. O'Keefe's jeans?
I was.
And from your comparative analysis from this questioned item to the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 4 contributors, including male DNA. The DNA profile from this item is at least 53 septillion times more likely if it originated from John O'Keefe and 3 unknown individuals than if it originated from 4 unknown, unrelated individuals. This provides support for an inclusion.
And again, sir, with that number, as far as 53 septillion times more likely, how many zeros in a septillion?
A septillion is a 1 followed by 24 zeros.
Now, sir, if I could turn your attention to what's listed as number 12 in your report, but item 7-18.4.1. Did you do some testing on that item as well?
Yes.
And what was the description associated with that?
Sample from stain C on top front of Gray's long sleeve shirt.
And the gray long sleeve shirt, is that attributed as belonging to a specific person?
Yes, John O'Keefe.
And were you able to generate a DNA profile from that item, specifically sample from stain C on the top front of the gray long sleeve shirt of Mr. O'Keefe?
I was.
And from your comparative analysis from that questioned item from the shirt to the known standard of John O'Keefe, what did you conclude?
So the male DNA profile was interpreted as originated from a single contributor. The DNA profile from this item is at least 58 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
And again, sir, that number, as far as 58 octillion times more likely, how many zeros in an octillion?
So an octillion is a 1 followed by 27 zeros.
Now, sir, if I could take you down to listed as 15 in your report, but did you do some testing on item 7-18.14.1?
I did.
And what was the description associated with that item?
So sample from stain L on back bottom right of gray long sleeve shirt.
And were you able to generate a DNA profile from that item?
I was.
And from your comparative analysis with reference to that item, the sample from stain L on the back bottom right of the gray long sleeve shirt, in comparison to the DNA profile from the known standard of John O'Keefe, what did you conclude?
So the DNA profile was interpreted as a mixture of 2 contributors, including male DNA. The DNA profile from this item is at least 1.0 decillion times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Now, sir, did you also perform some analysis on an item numbered 7-18.17.1?
I did.
And what was the description associated with that item, sir?
Sample from unstained areas of exterior of gray long sleeve shirt.
And similarly, were you able to generate a DNA profile from that item, the sample from the unstained areas of the exterior of the gray long sleeve shirt of Mr. O'Keefe?
I was.
And from your comparative analysis from that question item to that of the known standard of John O'Keefe, what did you conclude?
The DNA profile was interpreted as a mixture of 2 contributors, including male DNA. Contributor 1 is suitable for comparison. Due to limited information, contributor 2 is not suitable for comparison. The DNA profile from this item is at least 960 nonalien times more likely if it originated from John O'Keefe and an unknown individual than if it originated from 2 unknown, unrelated individuals. This provides support for an inclusion.
Thank you, sir. I'm going to group a couple, 4 separate items from your report, starting with what's listed in your report as number 9 is item 7-3.1, correct?
Correct.
And what is the description associated with that item, sir?
Sample from stain D on right instep of sneaker.
And 11 from your report, you also did some analysis on item 7-18.3.1, is that correct?
Correct.
And what was the description associated with that?
Sample from stain B on top front of gray long sleeve shirt.
And item 7-18.7.1, do you see that as well?
Yes.
And what was the description associated with that item? And lastly, in this group, item 7-18.8.1, what was the description associated with that?
Sample from stain G on back left sleeve of gray long sleeve shirt.
And with respect to each of those last 4 samples from those items, were you able to generate a DNA profile with respect to each of those 4?
Profiles were generated from them.
And what did you conclude based on the generation of those profiles with those 4 items?
Yeah, so the profiles that were generated were not suitable for comparison.
And if you could explain briefly to the jury, when you say not suitable for comparison, what do you mean by that?
Yeah, so for 7-3.1, it was a mixture of at least 5 contributors. And at the DNA unit, we validated, basically we tested and make sure that our protocols were we can only interpret mixtures of up to 4 contributors. So I determined that there were 5 contributors, so that makes it too complex for us to do comparisons to it. So it's not suitable for comparison for that reason. And the other 3 items, due to the quality of the profile, they were not suitable for comparison. And basically what that means is that there were such low amounts of DNA that was in the sample that there was a lack of information from the profiles themselves, so they weren't really suitable for comparisons.
And just to be clear, the item that you're referring to with the 5 possible contributors, that's a shoe, correct?
Correct.
Now, if I could turn your attention in your report to what you have listed as number 10, there are a number of different items listed there, correct?
Correct.
And starting with item 7-17.2.1, what is the description associated with that?
Sample from stain A on top front left of orange t-shirt.
And 7-17.3, what is the description associated with that?
Sample from stain B on top of front left of orange t-shirt.
And item 7-17.4.1, what is the description associated with that?
Sample from stain C on top front left of orange t-shirt.
And item 7-17.5.1, what is the description associated with that item number?
Sample from stain D on front bottom right of orange t-shirt.
And item 7-17.6.1, what is the description associated with that?
Sample from stain E on back left shoulder of orange t-shirt.
And so each of those respectively were samples taken from stains on the orange t-shirt of Mr. O'Keefe, correct?
Correct.
Now turning your attention to item 7-18.2.1, what is the description associated with that?
Sample from stain A on right sleeve of gray long sleeve shirt.
And item 7-18.5.1, what is the description associated with that?
Sample from stain D on center front of gray long sleeve shirt.
And items.
Okay, they were all at the bar, right? So the DNA, they can explain that on his clothes. Because they could have hugged, they could have patted each other on the back, whatever. They can explain it on the clothes. But the shoe, no one's going to reach down and touch your shoe. Like, you don't shake feet, you shake hands, right? So why would their DNA be on his shoe?
7-18.
At the very least, they could have compared the DNA on the shoe to the DNA on the shirt. The unknowns. They could at least compare those to see if they matched. I don't know if they did, but they could have done that at the very least.
6.1, what is the description associated with that?
Sample from stain E on center front of gray long sleeve shirt.
And item 7-18.9.1, did you?
Yes.
And what?
Back left of front gray, back left of gray long sleeve shirt.
And item 7-18.10.1, what is the description associated with that?
Sample from stain H2 on back left of gray long.
And item 7 associated
Sample from stain I on
with that.
Sample from stain J on back bottom right of gray long sleeve shirt.
And lastly, with this group search, item 7-18.13.1, what is the description associated with that?
Sample from stain K on back bottom right of gray long sleeve shirt.
And so each of those items beginning with 7-18 were associated with various stains taken from various gray long sleeve shirt of Mr. O'Keefe, correct?
Correct.
And with respect to each of those areas of the orange t-shirt and the gray long sleeve shirt, were you able to generate a DNA profile from those items?
I was.
And from your comparison,
So the male DNA profile was interpreted as it originated from a single contributor. The DNA profile from these items 190 octants more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
Now, again, if you could just remind the jury, when you say single source contributor, what does that mean?
Yeah, so a single source profile is a profile that has one contributor to it. So like one person contributed DNA to that profile.
And with respect to the number as far as 490 octillion times more likely, how many zeros are in that number?
So an octillion is a 1 followed by 27 zeros.
Now, lastly, sir, did you perform any analysis with reference to items numbered 8-2 and 8-3?
I did.
And what were the descriptions respectively for items 8-2 and 8-3?
So item 8-2 was right hand fingernail clippings from John O'Keefe, and item 8-3 were left hand fingernail clippings from John O'Keefe.
So fingernail clippings from both the right and left hand of Mr. O'Keefe.
Correct.
And were you able to generate a DNA profile from those item numbers, the right and left hand fingernail clippings of Mr. O'Keefe?
I was.
And based on, from your comparative analysis of the DNA profile from the right and left hand fingernail clippings, both of Mr. O'Keefe, taken in conjunction with the known standard of John O'Keefe, what did you conclude?
Yeah, so the male DNA profile was interpreted as originated from a single contributor, and the DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
So with respect to each the right and left hand fingernail clipping Keefe, both of those were identified by you or your analysis as a single source contributor, correct?
Correct.
And they were each 490 octillion times more likely to have originated from John O'Keefe than from an unknown, unrelated individual. Is that correct?
Correct.
Thank you. Thank you, sir. I have nothing further on.
May I, Your Honor?
Yes.
Good morning, sir.
Good morning.
Mr. Porto, I would like to start by asking you about item 3-1.1, which you've identified as a sample from the passenger side taillight of the vehicle. Can you orient yourself in your report to that item?
Yes.
And that, of course, was the passenger side taillight that was attached to the vehicle, correct?
Correct.
You were never asked to do any DNA comparison on any pieces of taillight connected with this case, correct?
Let me check my other report. For taillight, there was another item that was item 3-3.1, which is sample from apparent glass on rear bumper, if that's what you're referencing.
Okay, so if I suggested to you that the taillight was plastic, that glass wouldn't have been the taillight, correct?
I don't have, that's beyond my scope of testing.
Gotcha. Okay. With regard to the passenger side taillight, one of those contributors appeared to be John O'Keefe. Is that fair to say?
He was included.
All right. With regard to the other contributors, who were they?
They could be anybody.
Were you ever asked to compare DNA samples from either Canton Police Detective Kevin Albert or Canton Police Chief Kenneth Berkowitz to the DNA profile that you
I know the answer.
analyzed from that passenger side taillight?
I was not.
Now, with regard to the broken drinking glass, which is item 3-2.1.1, do you see your report?
I do.
With regard to that, you came up with a DNA profile that also had 3 contributors, correct?
Correct.
One of those contributors appeared to be John O'Keefe, correct?
He was included, correct.
Who were the other two contributors?
I don't know. They could be anybody.
Were you ever asked with regard to that broken drinking glass to compare the DNA profile that you analyzed with the DNA of either Boston Police Sergeant Brian Albert or ATF agent Brian Higgins?
I was not.
Did she allow it? What'd she
Now,
say?
with regard to 7.1.2.1, or maybe it's 7-1.2.1, that's the stain A from the upper right leg of the jeans.
Correct.
All right. And you were told that those were the jeans that John Oak was wearing on the morning when he was found?
Based on the sample description, that's what it seems.
All right. And it turned up that his DNA was on his own jeans, correct?
He was included in the profile.
All right. And that was unsurprising to you, correct? And with regard to that item, you found that there were 3 contributors of DNA, correct?
Correct.
With John O'Keefe being one of them.
He was included in the profile, yes.
And who were the other 2?
I don't know. They could be anybody.
Let's move on to stain B, also from the upper right leg of the jeans. That is 7-1.3.1. You see that in your report.
I do.
When you found a DNA profile, how many contributors of DNA were there?
3 contributors.
All right. And again, this was John O'Keefe's jeans, correct?
Based on the description, yes.
So he was one of the 3 contributors.
He was included in the profile, yeah.
Who were the other 2?
I don't know. They could be anybody.
Moving on to stain C from the upper right leg of the jeans, 7-1.4.1. You see that in your report?
I do.
With regard to the DNA profile that you analyzed there, how many contributors of DNA were there to that profile?
At least 2, and it was interpreted as 2 contributors.
And again, this is the same pair of jeans that he was found in, correct?
Based on the description, yes.
And you said at least 2 contributors. It actually could have been more than 2.
Based on our protocols, I had to call it 2, and we determined it as 2, but it could be more than 2, yes.
Okay. Well, let's pay attention to the one that was not John O'Keefe, at least that one. Who contributed that DNA to his pants?
I don't know. It could be anybody.
Moving on to stain D, which is 7-1.5.1. And if I can just put my glasses on to make sure I've read my own writing correctly. Actually, is it 7-15-1? Did I get that wrong the first time?
D?
I'm sorry?
Do you mean
Stain D? Stain D.
Stain D is 7-1.5.1.
Oh, I had it right the first time. Okay.
Right.
With regard to that stain, you also got a DNA profile. And how many contributors were there to that DNA profile?
I interpret it as 3 contributors.
And again, this John O'Keefe's genes, correct?
Correct.
He was one of the contributors to his own genes, correct?
He was included in the profile.
And with regard to that stain on the upper right leg of his jeans, who contributed the DNA to who were the other 2 contributors of DNA to that stain?
I don't know. They could be anybody.
And then finally, with regard to that upper right leg of the jeans, there was also a stain E, correct?
Correct.
How many contributors did you find to that DNA profile?
2 contributors.
One of which was John O'Keefe to his own genes, correct?
He was included, yes.
And who was the other contributor to that stain on the jeans?
It could be anybody. I don't know.
And by the way, just for the record, that was 7.1.6.1?
7-1.6.
7-1.6.1. Okay, now, with regard to the item 7, you found a DNA profile with regard to that unstained area as well, correct?
Correct.
How many contributors of DNA were there to that unstained area of the gene?
I interpreted it as 4 contributors.
And John O'Keefe was one of those, correct?
He was included in the profile.
His own genes.
Based on the description, yes.
Who were the other 3 contributors to that DNA profile?
I don't know. It could be anybody.
And before we move on to the sneaker, I just wanted to ask you a question about the passenger side taillight that I neglected to ask you. That was the one where there were 3 contributors, correct? And again, I'm going back to 3-1.1.
Correct.
Sorry to skip around, sir.
Okay.
I'm not trying to make this
It's all
any
right.
more confusing than it is. With regard to the passenger side taillight and that DNA profile, are you able to determine when that DNA was deposited on the passenger side taillight that was attached to the vehicle?
No, I'm not.
Are you able to testify with any certainty that it was deposited there, say, on January 28th or 29th of 2022?
No, I can't.
So consistent with your analysis of it, are you able to say whether it occurred prior to January 28th of 2022?
No, I can't.
Were you aware that that vehicle was John O'Keefe's girlfriend's vehicle?
I was not.
Were you provided any information about just how often he had been in and around that vehicle prior to January 28th of 2022? So moving on to 7-3.1, which was the right instep of the sneaker, correct? You see that in your report?
Yep.
With regard to that particular stain, you noted how many contributors of DNA?
Yeah, it was interpreted as at least.
You have interpreted as at least 5 contributors. What does that do to your ability to find out who contributed that DNA?
So based on our protocols, we're not able to do any comparisons to any mixtures that are 5 or more contributors. So it's not suitable for comparisons.
Okay, which means that with regard to the sneaker, at least, you couldn't even say whether John O'Keefe's DNA was on it, correct?
Correct.
And with regard to all 5, do you have any idea who contributed the DNA to that sneaker?
No, I don't.
Now,
I wonder if they can tell
moving on to, I just have a couple more for you, sir. Moving on to what is labeled as stain L, which is 7-18.14.1, I believe. Do you see that in your report?
I do.
And that was a stain on the back bottom of his long sleeve shirt, correct?
Correct.
And were you told that the long sleeve shirt was his outer clothing when he was found?
I don't believe so.
How many contributors to that stain on the back bottom of his long sleeve shirt did you find in that DNA profile?
I interpreted it as 2 contributors.
And did you make any match with regard to either of those contributors or both?
I did comparisons, and John O'Keefe was included as one of the contributors.
Okay, so John O'Keefe was a contributor of DNA to his own long sleeve shirt, correct?
Based on the descriptions, correct.
All right, and whose other DNA was on that shirt?
I don't know.
And then finally, with regard to 7-18.17.1, that was an unstained area of the exterior of that shirt, correct? That same long sleeve shirt.
Correct.
And you tested that and got a DNA profile, correct?
Correct.
How many contributors were there to that DNA profile?
I interpreted it as 2 contributors.
Was John O'Keefe one of them?
He was included as one of the contributors.
Okay, so his DNA was found on his own shirt, correct?
Based on the description, correct.
And who contributed the other DNA profile to John O'Keefe's sweatshirt?
I don't know.
With regard to any of the stains on...
You would think her DNA would be on his clothes too, if they were lovey-dovey the night before. Did he say whether the DNA was male? I think he said the other DNA was male, though. Why wouldn't her DNA be on his clothes? Her DNA should be on his clothes too. Because in the last trial, everybody said they were lovey-dovey. Her touch DNA should be on his clothes too. Is that weird? Am I making more of that than I should? I don't know why this just now dawned on me. Her touch DNA should be all over him.
The upper right leg of the jeans, I counted 1, 2, 3, 4, 5 that you've discussed here today. Were you ever asked to compare the DNA profile with the DNA profiles of either Brian Higgins or Brian Albert?
I was not.
Oh.
And your answer was you were not?
I was not.
Did anybody ever provide you with DNA profiles of Brian Higgins or Brian Albert?
Sustained to that.
I may have one moment, Judge.
Proctor, why'd they take swabs of Proctor and Buchanan?
I just have one more question for you, Mr. Porto, and I do want to thank you for answering all my questions here today. You wrote reports on your analysis of all the items and the work that you did on this case?
I did.
And you are directed pursuant to protocol to address those reports to somebody, correct?
Correct.
Who was it that you sent the reports to in this case?
I'm sustaining the objection.
Did you send those reports to Michael Proctor?
Sustain. Jurors, strike the question.
I have nothing further. Thank you, sir.
Why? I need grounds, Beth.
Yes.
Would you please stop? I need to understand why they're objecting.
Mr. Porto, based on your training and experience and years of doing DNA testing at the lab, when it comes to samples from items of clothing, is it uncommon or common to have multiple contributors?
That depends. It can happen, but it's possible, yes.
Is it something that's a complete anomaly?
I wouldn't say so, no.
Now, turning your attention back to item 3-1.1, that's the sample from the passenger side taillight of the defendant's vehicle, correct?
Correct.
And Mr. O'Keefe was found to, his known DNA profile was found to be an inclusion for the DNA profile from the swab from the defendant's passenger side taillight, correct?
He was included in the profile, yes.
And to what statistical, what is the number associated with that inclusion, sir?
The DNA profile from this item is 510 non-alien times more likely to have originated from John O'Keefe and 2 unknown individuals than if it originated from 3 unknown, unrelated individuals.
And Mr. Porter, if I could turn you back to number 10 in your report, there's a number of different items listed there, correct?
Correct.
And as far as the items listed associated with various stains on various areas of Mr. O'Keefe's orange t-shirt and gray long sleeve shirt, there's about 13 different DNA profiles that you generated in reference to those items, correct?
Correct.
And from those 13 different items, they're all from a single contributor, is that correct?
Correct. They were interpreted as originated from a single contributor.
And as far as the DNA profile, your comparison of each of those 13 different stains on the orange t-shirt and the gray long sleeve shirt, what were your conclusions again as your comparison with the known standard of John O'Keefe?
Yeah, so the profile was interpreted as originated from a single contributor, and the DNA profile from these items is at least 490 octillion times more likely if it originated from John O'Keefe than if it originated from an unknown, unrelated individual. This provides support for an inclusion.
And lastly, with reference to the fingernail clippings from both the right hand and the left hand of Mr. O'Keefe, those were also, your analysis provided for inclusion of Mr. O'Keefe's known DNA standard, correct?
He was included in the profile, correct.
And again, the profile from both the right hand and the left hand fingernail clippings was a single source contributor, correct?
Sustain.
How many sources were associated with those?
Objection.
Sustain.
Nothing further.
Okay, you all set, Mr. Unity?
Yes, Your Honor, thank you.
You are all set, Mr. Porter. Thank
Thank
you
you.
very much.
You know, because
Who is the next witness?
The Commonwealth will call Ashley Valier to stand.
Okay.
guys don't scratch when they fight. Girls scratch. Girls bring the claws out. Guys don't. Guys punch. Girls scratch. If it was a girl, then you would find DNA under fingernails. Right, girls? Back me up here, am I right?
You solemnly swear the evidence you give the court and jury in the case down here is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Oh, I remember.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, Ms. Valier.
Good morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
My name is Ash Valier, spelled Vallier.
And where do you work?
I work at the Massachusetts State Police Crime Laboratory.
And where did you go to school?
I got my bachelor degree in biochemistry and cell biology from UC San Diego and a master degree in biomedical forensic sciences from Boston University.
Now, following your education, where did you go to work from there?
Directly after I got my degree at Boston University, I worked at the Broad Institute.
And what did you do at the Broad Institute?
I did quality control checks of items that potentially could be tested for pharmaceutical use.
Now, how long have you worked at the Massachusetts State Police Crime Laboratory?
A little over 6 years.
Now, is the state lab accredited?
It is.
And by whom?
ANAB.
And what does ANAB stand for?
It stands for ANSI National Accreditation Board.
And the ANSI within the ANAB, what does that stand for?
That is another acronym that I don't recall right now.
Now, as part of that accreditation process, do you undergo any sort of type of proficiency testing?
I do.
And can you explain to the jury what that proficiency testing process consists of?
A proficiency test is a test that is given from an outside agency in the discipline that you do casework in, that you would work through like a normal case, but it has an end expected result at the end.
And how often do you undergo proficiency testing?
Every year.
And what areas do you specifically undergo proficiency testing in?
I've done proficiency tests in gunshot primer residue and physical match analysis.
And have you successfully completed each of those proficiency tests that you've taken?
I have.
Now, when you initially joined the State Police Lab, what was your position and title that you were hired for?
I was hired as a forensic scientist 1.
Now, can you please explain to the jury what your duties and responsibilities were as a forensic scientist 1?
So a forensic scientist 1 is the introductory level. It's when you start your training in whatever discipline you're going to be trained in and quality control checks. After you've been at the laboratory for over a year and you're signed off to do casework, you become a forensic scientist 2.
And you're currently a forensic scientist 2, is that correct?
Yes.
What is the difference between a forensic scientist 1 and a forensic scientist 2 at the Massachusetts State Police Crime Laboratory?
A forensic scientist 2 has been at the lab for over a year and can do casework.
Now, just in general terms, what does the trace unit do or examine within the State Police Crime Laboratory?
I'm a part of the trace, arson, and explosives unit. So we analyze a wide range of pieces of evidence. So there's trace covers a lot of small things. So paint, fibers, glass, gunshot primer residue, physical matches. Arson covers.
Specifically with reference to physical match analysis, can you explain to the jury, just in general terms at first, how is that analysis performed?
So physical match analysis is piecing broken things together to see if they were at once a single item. Generally, you look at the questioned item first, the item that you don't know specifically where it came from. Look at that. And then you would look at the known item, which is an item with a known source, like specifically like this window or like this vehicle. They're analyzed at separate times. And then if it looks like there could potentially be a physical match, you would analyze them together and see if they have a mechanical fit.
Now, when you retrieve items just in general to do some sort of physical match analysis, where do you get those items from?
Where
And how?
Cardboard boxes, brown paper bags, heat sealed plastic bags. It depends on the individual items.
And when you're doing this analysis, as far as the physical match analysis, what do you do to your bench between your examination of separately packaged items?
I mean, before I do any analysis, I bleach my bench, clean my tools, and then put down a fresh sheet of butcher paper.
And why do you do that?
To make sure everything's clean.
Now, again, speaking more in general terms, on what types of evidence can you perform a physical match analysis?
Sorry, can you repeat the question?
Sure. In general terms, with your work within the lab, on what types of items can you perform a physical match analysis?
A lot. Anything that has a broken or irregular edge.
Would that include glass?
Yes.
Would that include plastic?
Yes.
What are some of the other things that would also include?
Any sort of like polymer, metals.
And when you're doing a physical match analysis, what instruments do you utilize in the course of that analysis?
Generally, I'll use a stereo zoom microscope. Depending on the size of the items compared, I can use other microscopes as well.
Now, what is a stereo zoom microscope?
A stereo zoom microscope is a microscope that's mounted on a stand. So it gives a wider range of view that you can look at larger items.
And how are you using that specifically in your physical match analysis of, let's say, items of plastic?
I'll use it to look at the edges and see if there's any like defining characteristics along those broken edges.
Now, as you're going through your analysis, do you document your work as you go?
I do.
And how do you do that?
With handwritten notes and with photos.
Now, at some point, were you assigned to perform some work on lab case number 22-02184 pertaining to this defendant, Karen Reed?
Yes.
And what type of work were you assigned?
Later on, I was asked to look at, do some trace recovery, look at some debris.
Starting with the physical match analysis, how many different items approximately were you asked to look at?
Over 10.
Several, fair to say?
Yes.
Okay. And how were each of those items packaged when you received them?
So the questioned items were packaged first in a large paper bag, and then each item was individually packaged in a smaller brown paper bag within that container.
Now, again, just in general terms, because you've used it a couple times. When you say questioned item versus known item, as it pertains to this analysis in this case, what were the questioned items generally, and what was the known item?
The question items were items labeled as coming from a road, and the known item was labeled as coming from a taillight from a vehicle.
Now, in this case, did you perform your physical match analysis in the same manner that you've previously described based on your education, training, and experience within the lab?
Yes.
Now, initially, you had examined some various plastic and glass items, and there was a drinking straw in there as well, correct?
Yes.
And specifically, as far as the item numbers that you looked at in this physical match analysis, could you provide the jury with the list of just the item numbers first to start with?
May
Your
I?
Honor.
Have your report with you, Ms. Willett?
I do.
Okay. Is there any objections to me using the report?
No objection at all.
So feel free to use it.
Thank you, Your Honor.
So the questioned items labeled as coming from the road were item 7-5, item 7-6, 7-8, 7-9, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, 7-16, and 7-19. And the known item labeled coming from the passenger side taillight is item 3-1.
Now, Ms. Valier, within those specific item numbers of how things are labeled at your lab, if there are different pieces associated with the same item, how is it that you label those specifically in this physical match analysis here?
So some of the items had multiple pieces within that item. So I labeled them A, B, C, etc., depending on how many pieces there were.
Now, if you could, please explain to the jury just, again, the process that you followed in your examination of each of those items.
So first I looked at the questioned items, the items labeled as coming from the road. I looked at, I documented the overall package because they were all packaged in the same container, the same brown paper bag. Documented that individually. Inside of it, there were a bunch of individual brown paper bags. Documented that, and I went one at a time through them, opening each paper bag, taking written notes, taking photos of the items inside. Within each item, I looked to see if any of those pieces fit together. And I cleaned my bench in between the items.
Your Honor, may I approach?
Yes.
And Your Honor, those quotes I've shown Mr. Yannetti all in advance.
Okay. Is there an objection to any of them, Mr.
No
Mayor?
objection, Your Honor.
All right, so why don't we just go ahead and mark them all as evidence?
Your Honor, if I could, I was going to take them item by item.
Okay, that's fine. Okay.
Ms. Blair, I'm showing you 4 photographs. You recognize those?
I do.
What do you recognize those to be?
These are photos that I took of item 3-1.
Again, what was the description associated with item 3-1?
Passenger side taillight.
And was that description further give sort of a specific vehicle or license plate associated with the vehicle that the taillight came?
It does. Massachusetts 3GC684.
And the Commonwealth will seek to introduce and admit as the next exhibit A through D.
Right, those are clear. That's why I wanted to just mark them all because they're all clear, right?
That's fine. If the court prefers, I can provide them.
All right.
Exhibits 170A through 170D.
May I approach with the remainder, Your Honor?
Yes. If you have them in sections, we can do that.
I'm showing you more photographs. Just ask to recognize those.
I do.
And recognize those.
Photos on 7-5.
And I think we'll see description in reference to item 7-1.
Yeah.
Thank you. You're fine. It's just yes.
Okay. Piece of plastic, red, recovered from 34 Fairview Road.
And Your Honor, the Commonwealth seek to introduce and admit as the next exhibit A and B.
Okay.
Exhibit 171A and B.
My apologies, Your Honor. With the court's permission, may I publish some of those?
Yes.
photos to the jury? Ms. Gilman, if I could first ask for
He doesn't
photograph
stop.
2122.
There's no pause. between your analysis. He says your analysis.
And Ms. Valier, what's up on the screen? That is the bag associated with the passenger side taillight or the known item, correct?
Correct.
And Ms. Gilman, if I could have a photograph 2125. And Ms. Gilman, if you could just enlarge a little bit towards the bottom where the ruler is. Now, Ms. Valier, what's up on the screen now as far as the sort of notations there? Who made those?
I did.
And how do you know that you were the one who made those?
That's my handwriting, and those are my initials.
So the AMV is for your name, correct?
Yes.
And with respect to each of the items that you photographed, you had photographs that were taken of sort of what was in the evidence bag in total, displayed on your table that you would clean with the solution and everything else, correct?
Yes.
Okay. And Ms. Gilman, if you could just zoom out a little bit to show the item. And again, what's up on the screen, that is item 3-1, the known item as far as the tail light from the defendant's vehicle.
Yes.
And Ms. Gilman, if I could have 2126. And Ms. Valier, if you could just describe for the jury, what are we looking at in this photograph?
Those are those same items just turned over.
And lastly, for this set, Ms. Gilman, if I could have 2135. And again, same item as far as 3-1, the tail light taken from the defendant's vehicle.
Yes.
Ms. Gilman, if I could ask for photograph 1905. And Ms. Valier, as far as with each of these items, you take photographs when they're inside the bag and then once you take them out of the bag, correct?
Yes.
And Ms. Gilman, if I could have photograph 1908. And what are we looking at in this photograph?
The contents of item 7-5.
May I approach again, Your Honor?
Yes.
We need 2 more photographs. Do you recognize those?
I do.
And what do you recognize those?
Photos of item 7-6.
That's one of the bag and then one when the item is taken out of the bag. Is that correct?
Yes.
And what was the description for item 7-6?
Piece of plastic, clear, recovered from 34 Fairview Road.
I appreciate those. Your Honor, Commonwealth will seek to introduce in the minutes the next exhibit, A and B.
172 A and B.
With the court's permission, may I publish those to the jury?
Yes.
Ms. Gilman, if I could have photograph 1921 and then photograph 1924. And what's depicted up on the screen is that what you just have before you as the photograph that you took of item 7-6 recovered from 34 Fairview Road.
Yes.
Thank you. May I approach the witness again, Your Honor?
Yes.
Other photographs, review those. Can you recognize those?
I do.
What do you recognize as?
Photos I took of item 7-8.
And one of the bag and then one of the items removed from the bag, is that correct?
Yes.
And what is the description associated with item 7-8?
Piece of plastic, red and clear, recovered from 34 Fairview Road.
Commonwealth seek to introduce in the minutes the next exhibit, A and B. And Your Honor, with the court's permission, if I could publish those to the jury.
Yes. Exhibits 173 A and B.
Ms. Gilman, if I could have photograph 1931 and then 1934. And Ms. Gilman, if you could zoom in just a little on those items, please. And Ms. Valier, again, what are we looking at in this photograph of item 7-6? What are we looking at again in this photograph? Excuse me.
Photos of item 7-8.
May I approach the witness again, Your Honor?
Yes.
Two other photographs. And do you recognize those?
I do.
What do you recognize those?
Photos of item 7-9 and 7-19.
And as far as the first photograph, as far as the bag, and then second with the items taken out of the bag, is that correct?
Yes.
So 7-9 and 7-19 were contained in the same bag.
They were. I then separated them into 2 separate packages.
And as far as 7-9 and 7-19, respectively, if you could tell the jury what was the description for each of those items.
Item 7-9 was pieces of glass recovered from 34 Fairview Road. Item 7-19 is trace item black straw recovered from 34 Fairview Road.
Commonwealth seek to introduce in the minutes the next exhibit, A and B. May I publish, Your Honor?
Hold on.
Oh, forgive me.
74A, 174B.
Now you can publish.
My apologies. Ms. Gilman, if I could have 1958, please. And then 1962. And again, Ms. Lear, what are we looking at in this photograph?
The contents of that bag, item 7-9 and item 7-19.
May I approach again, Your Honor?
Yes.
Two other photographs, do you recognize those?
I do.
What do you recognize as?
Photos of item 7-10.
And again, one of the bag and one of the contents of the bag, is that correct?
Yes.
And if you could, please tell the jury what was the description for item 7-10.
A piece of plastic, red, recovered from 34 Fairview Road.
I want the suit to introduce in the minutes the next exhibit, A and B.
Exhibits 175A and B.
May I publish that for the jury, Your Honor?
Yes.
Ms. Gilman, if I could have 1952. And 1956. And again, Ms. Lear, what are we looking at in this photograph?
Photo of item 7-10.
Thank you. Gilman, you can take that down. May I approach the witness, Your Honor?
Yes.
Two other photographs, do you recognize those?
I do.
And what do you recognize those?
Photos of item 7-11.
And again, one photo of the bag and one photo of the items outside of the bag.
Yes.
And again, if you could, please tell the jury what the description is associated with item 7-11.
Piece of plastic, 6, red, clear, and black, recovered from 34 Fairview Road.
Commonwealth is seeking to introduce in the minute as the next exhibit, A and B.
Exhibits 176A and B.
And may I publish, Your Honor?
Yes.
Ms. Gilman, 1979 and 1982. Again, Ms. Lear, I'm sorry, Ms. Gilman, if you could zoom in just a little on the items themselves. And Ms. Lear, what are we looking at in this photograph?
Photo of item 7-11.
These are photos, again, that you took in the lab during the course of your comparative or physical match analysis, correct?
Yes.
May I approach again, Your Honor?
Yes.
Two other photos, you could look at those. Do you recognize those?
I do.
And what do you recognize those?
Photos I took of item 7-12.
And again, photograph of the bag, photograph of the items outside of the bag.
Yes.
And if you could, please tell the jury what's the description of item 7-12.
Trace item, 14 glass and clear plastic, recovered from 34 Fairview Road.
The Commonwealth will seek to introduce in the minutes the next
Okay.
exhibit, A and B.
Exhibit 177A and 177B.
Your Honor, may I publish?
Yes.
Ms. Gilman, if I could have photograph 2015 and 2018. And again, Ms. Gilman, if you could just zoom in a little on the items. Thank you. And Ms. Valier, again, what can you describe what's depicted up on the screen?
It's a photo I took of item 7-12.
Your Honor, may I approach?
Yes.
Two other photographs. Do you recognize those?
I do.
And what do you recognize those?
Photos I took of item 7-13.
And again, one of the bag and then one with the items removed from the bag.
Yes.
And if you could, please tell the jury what is the description for item 7-13.
Piece of plastic, red and black, recovered from 34 Fairview Road.
I'll look to seek to introduce in the next exhibit A and B.
Exhibit 178A and 178B.
Your Honor, may I publish?
Yes.
Ms. Gilman, 1997. And 2000. And again, Ms. Gilman, if you could, please zoom in on the items. Thank you.
Well, they're numbered different, so I don't know.
And Ms. Valier, directing your attention to the screen, can you
I'm
describe
not
to the
seeing
jury
that.
what is depicted on the screen now?
And I'm not.
A photo I took of item 7-13.
Takes a lot for me to do math. I gotta have
May I
a
approach the witness, Your
board.
Honor?
Yes.
Two other photos. Do you recognize those?
I do.
What do you recognize that?
Photos I took of item 7-14.
And again, one of the bag and one of the items removed from the bag.
Yes.
And again, can you please tell the jury what the description is associated with item 7-14?
Pieces of glass recovered from 34 Fairview Road.
I want to seek to introduce the next exhibit, A and B.
Exhibit 179A and B.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2009 and 2012.
It's
And
in
again,
the
Ms. Gilman, if you could zoom in on
Or
the item.
just they're making up a number.
Clear as far as what's depicted on the
Start
screen
at one
again, if you could describe for the jury what that is.
A photo of item 7-14.
May I approach the witness again, Your Honor?
Yes.
Specters on octuple, whatever letter.
Other photographs, if you could recognize those.
I do.
And what do you recognize that?
Photos of item 7-15.
And again, one of the bag and one of the items taken from the bag, correct?
Yes.
And if you could, please tell the jury what is the description associated with item 7-15.
Piece of plastic, 3 clear and 5 red, recovered from 34 Fairview Road.
The Commonwealth will seek to introduce and admit as the next exhibit, A and B.
180A and 180B.
May I publish, Your Honor?
Yes.
Gentlemen, if I could have 2072.
Yes.
Yes.
And 2077, please. Again, if you could zoom just a little as far as the items are concerned. And Ms. Valier, what are we looking at in this photograph?
Item 7-15.
May I approach again, Your Honor?
Yes.
Other photographs, do you recognize that?
I do.
What do you recognize that?
Photos I took of item 7-16.
And again, one of the bag and then one of the contents from the bag, is that correct?
Yes.
And if you could, please tell the jury what was the description associated with item 7-16.
Piece of plastic, red and clear, recovered from 34 Fairview Road.
I'm about to seek to introduce the minutes of next exhibit.
Exhibit 181A and B.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 2036 and 2040. And Ms. Gilman, if you could zoom in just a little. Thank you very much. And Ms. Valier, if you could, please describe for the jury what we're looking at in this particular photograph.
This is item 7-16.
Ms. Gilman, you can take that down. Now, with respect to each of these items that you examined in your physical match analysis, again, as far as the process is concerned, with the questioned items, what are you doing with reference to each of those questioned items first?
First, I document them as you've seen. I'll see if any of those within the item have a physical match with each other. And then I'll package that away and look at all the questioned items before I compare inter-questioned items to see if there are any physical matches in between all of the 7- items.
And as far as your notes are concerned, what is it that you're noting in reference to each of those items, as far as what characteristics of the item are you taking note of?
I'll note the size, the color, and the material.
And what, if any, measurements do you take of each of those respective items as well?
I'll take the length and width of each item.
Now, with respect, starting with item 3-1, the passenger side taillight from the defendant's vehicle, sort of internally within that item 3-1, what did you conclude as far as your physical match analysis within that item alone?
Within item 3-1, I believe 4 of the pieces fit together.
And Your Honor, if the witness may refer to her notes
Yes.
as to, thank you.
Yes, four of the pieces fit together within item 3-1.
And which 4 of the pieces?
Pieces A, B, D, and F.
And as far as the labeling of those pieces of an individual item, let's just start with item 3-1. A, B, D, and F, how are they labeled, and how do you sort of physically label those items?
We have a label maker in the lab, so I'll print out the case number, the item number, and then A, B, C, and my initials, and that goes physically on each of those items, or all of those pieces.
So if any of those items had a sticker on it with a letter or something associated with that, that would be something that you did during the course of your physical match analysis, correct?
Yes.
Now, if I could turn your attention to item 7-5, piece of plastic, red, recovered from 34 Fairview Road. What did you conclude as far as your physical match analysis just within that single item?
There was no physical match noted among those 3 pieces of apparent plastic.
Match found from the different pieces.
The broken edges of each piece did not align.
So the broken edges of the individual pieces within item 7-5 did not fit together with the broken edges of pieces within item item 7-5, correct?
Yes.
Now, with respect to item 7-6, a clear piece of plastic recovered from 34 Fairview Road. What did you conclude based on your physical match analysis just pertaining to that item 7-? On your physical match analysis just pertaining to that item 7-6.
So this item was those two pieces.
Now, with reference to item 7-8, red and clear plastic recovered from 34 Fairview Road, what did you conclude in regard to your physical match analysis just with the pieces contained within item 7-8?
So there were 14 pieces. Pieces C and D fit together, and pieces E and F fit together.
And when you say fit together, is there a term of art used within your field called a mechanical fit?
Yes.
And can you explain to the jury what you understand that term to mean as far as what is a mechanical fit?
So a mechanical fit and a physical match are the same thing. It's when the broken edges align together to show that they were once a single item.
Now, if I could turn your attention to item 7-9, pieces of glass recovered from 34 Fairview Road. What were you able to conclude from your physical match analysis of just the individual pieces contained within item 7-9?
So this item had 3 pieces, and no physical match was found between those.
Turning your attention to item 7-10, red pieces of plastic recovered from 34 Fairview Road. What were you able, that is a single item, is that correct?
Correct.
So no physical match because there's nothing to match, it's just one piece, correct?
Correct.
Okay. And turning your attention to item 7-11, identified as 6 red, clear, and black pieces of plastic recovered from 34 Fairview Road. What did you conclude in regard to your physical match analysis just within those pieces contained within 7-11?
So the item had 6 pieces, and there was no physical match noted among those 6.
Now, turning your attention to item 7-12, which was identified as 14 pieces of glass and clear plastic recovered from 34 Fairview Road. Again, what did you conclude from your physical match analysis just from the various pieces contained within item 7-12?
So there were 14 pieces overall. Pieces B, C, D, F, and K fit together mechanically as one unit. And then pieces E and I fit together mechanically as one unit. And pieces M and N fit together mechanically as one unit.
Now, through your examination of these pieces in particular and other pieces as well, did you note any debris contained on the pieces that you located?
Yes.
And can you say anything as far as what that debris was, or was there any analysis done of that debris specifically?
I just note that there was debris present, and I package it into a tin that's retained with the original packaging.
Now, turning your attention to item 7-13, that was a piece of plastic, red and black, recovered from 34 Fairview Road. Is that correct?
Yes.
And again, just with respect to your physical match analysis of the various pieces of 7-13, what did you conclude?
So that item had 3 pieces, and there was no physical match noted among those 3.
And again, with reference to item 7-14, piece of glass recovered from 34 Fairview Road, that was again a single item, correct?
A single piece, yes.
So I'll turn your attention to item 7-15, 3 clear and 5 red pieces of plastic recovered from 34 Fairview Road. Is that correct?
Yes.
And what were you able to conclude from your physical match analysis, again, just from the various pieces contained within item 7-15?
So there were 8 pieces in this one. Pieces F and H fit together mechanically.
Turning your attention to, lastly for this purpose, item 7-16, piece of plastic, red and clear, recovered from 34 Fairview Road. What were you able to conclude from your physical match analysis just contained within the pieces of that single item 7-16?
So that item had 7 pieces. Pieces A, C, and D fit together mechanically.
Now, Ms. Valier, once you had examined each of those pieces individually, what did you do next in your analysis?
Next, I compared all of the inter-questioned, these items 7-5 to 7-16. I compared them to see if there was a mechanical fit amongst those, between those items.
Mr. Lally, is this a good place for our break?
It's perfect. Yes, Your Honor.
All right, jurors, we'll take our morning break. We'll see you back here in about 15, 20 minutes. Thanks for letting you can walk out right back to jurors.
Mr. President, jury.
And can I see counsel for a minute, please?
Hey, guys. That was nice and boring. But I do have good news. So Judy sent me something yesterday about the buffer zone in front of the courthouse, and I totally forgot to look at it because pretty much my brain is fried in the afternoon when I get done. Especially when, like, I hit him and all that crap, right? And now we've got this long string of lab people and stuff, and it gets tedious, right? I picked up yesterday afternoon with the medical stuff. Like the first part of her testimony, I was like, oh my God, please move on. And then it was medical, and I was so bored. I was like, geez, if I'm bored, what is the jury thinking? Right? But then in the afternoon, when I was like, ooh, like I'd never used when there were spots, but I understood it. Like, and then we're talking about the rugae and the stomach lining and the ulcers because of the alcohol and the proton pump inhibitors and all that. I was, ooh, like I worked up. I was like liking that testing and DNA and I'm just like, oh, can we get past this? Can we please? And then I saw a post from Turtle Boy. This Massachusetts is ashamed of itself. It's ashamed of itself. But this is good though. It was terrible what happened, but it had a good result. Beverly Cannoni was told by the First Circuit Court of Appeals that she had 48 hours to revise the buffer zone restriction after a woman was forced to walk to her car in a sports bra after police ordered her to remove her sweatshirt and t-shirt. That's because the order, that wasn't even the buffer zone order. That was the don't anything, supporting and read crap. Can you imagine? Can you imagine having to walk? What was the buffer zone, Judy? Like 200 feet? Was it 200 feet? Or was that the old buffer zone? Can you imagine having to walk to your car in just your bra? In front of everybody, all those people standing out there in front of the courthouse because you had on a pink sweatshirt and t-shirt, have to walk in your bra. What if her bra had been pink? Would they have made her take her bra off too? And then they would have probably turned around and arrested her for indecent exposure. That's ridiculous. Supporters are now free to sit or stand wherever they want, so long as they are not being too loud or blocking people from getting into the court. That ticks me. Man, that makes me mad. Because as a woman,
All right, Mr. Lessie, I'll hear you.
You are unmuted.
make me walk in my bra because I got on a pink shirt or whatever.
Thank you, Your Honor. Yesterday, Your Honor discussed with the parties, and parties were heard with regard to the issues we have raised with regard to the timing of the May 8th report from Mr. Burgess that the defense received on May 11th. And what I want to ask for yesterday, which was how much time we might need under various circumstances. And so I wanted to take a few moments to put that in context. It will only take me a brief amount of time to do so. So, Your Honor, there is a timing issue, but there's most importantly a substantive issue. I will not, of course, go into the detail of yesterday, but the timing really is informed by the substantive issue. And so with regard to the matter, we went back and we looked at more deeply the effect of this timing and this movement of the what has been referred to as clock drift in Mr. Burgess's report that we got on May 11th. I spoke of the significance yesterday, and here's what I would like to add as is relevant to the time we're going to need.
No, Alessi, it's not clock drift. It's time wibbly wobbly, timey wimey. Get it right.
Again, urge the court to reject it substantively, because what we did was we went and we looked at matters such as the cross-examination of a key witness in this case, Jennifer McCabe. She testified with regard to observing a vehicle at 12:45 a.m. We, and that's a significant point. I know I don't need to elucidate for Your Honor. All of this is going in significant part, if not total part, to what has been as alleged a collision here, which we vigorously contest. No collision ever occurred. But the timing of it, the timing of what's alleged by the Commonwealth is very important. The seconds are important. Literally 1 second can turn not only the Commonwealth's theory completely around in circles and debunk it, but also the jury's analysis of it. And this is the point I wanted to elucidate today, is that the jurors have been provided information, and the defense has aimed its defense on this claim based upon, in large part, timing. So now what we have is on May 11th, Mr. Burgess changing the timing. So what does it affect? Not only witnesses like Jennifer McCabe, who we strategized with regard to, but also my decision to not even cross Trooper Garino, because Trooper Garino had testimony with regard to when Ms. Reed connected with the Wi-Fi at One Meadows, and there's a certain time associated with that. We have Mr. Whiffen, who went through, the Commonwealth went through a timeline, and we believe they went through a timeline for the theory that they had. And I cross-examined Mr. Whiffen extensively with regard to that timeline. There were several defense strategies, and effectuations of strategies based upon that timing. So with regard to the substance, Your Honor, and there's more, but I think that's a fair representation. It innervates our entire time it will take the defense to react to Mr. Burgess. I wanted to say it's not only a reaction, but it's a substantive defense analysis, and 3/4 of the effectuation of that has already occurred through our presentation in terms of cross-examination. So we would have to and we're still evaluating that, revisit all of that. And secondly, we would have to put that into the calculation of all of our witnesses that we've already prepared that are based upon that timeline. So it is a very significant point. And to the extent that the Commonwealth tries to argue, well, you know, we never really committed that much to a certain time period. I again urge the court to look at the report of Dr. Judson Welcher, where he has 1162-2 with a specific range, 38 to 43. And even in their range, it's a very small time, which further supports how each second matters in this regard. Now to the answer to the question Your Honor asked yesterday. Again, I urge that it just be rejected and we keep this trial moving in its current pace. To the extent that that does not occur, and again, we urge that it be rejected, the report, because it's a Rule 14 violation, there is no remedy for the defense. However, to the extent, and given Your Honor nonetheless asked me for an answer in time, we would need 4 days to be able to address it. We will not ever be able to recover strategically or substantively from it, given all that's been presented to the jury. And it will be very difficult to figure out how we're going to go present a defense after we've already presented to the jury our defense and our cross-examination. It's not really structurally possible to simply take 4 days and address Mr. Burgess, because we can't go back to all the witnesses I just mentioned and others and start crossing them in eliciting testimony with this new time period in mind. But I wanted to answer the question, Your Honor, respectfully. It would be 4 days for us to even go from where we are now and then try to alter not only witnesses such as Arca, but DeSogra and Gaffney and other types of witnesses that we have in that regard. So my, Your Honor, respectfully, that is my response.
All right. Does the Commonwealth want to be heard?
Yeah.
Okay.
He does. Darn you, Brennan. That is screw it all up.
Respectfully, Your Honor, the defense is very confused. They attempt to confuse the issue. They attempt to confuse Your Honor about what the impact would be. This has never been a change. The government is not changing their timeline. The Commonwealth is not changing any information. The Commonwealth is not offering anything that affects in any way the testimony of witnesses. It's notable in the argument there is no relationship to the facts or the actual report that was provided. The Commonwealth has always provided the data, which they have, and they hadn't a chance to analyze. And the interpretation of the data has been different between the parties. We have been clear from the beginning at the time in which the infotainment system shows that there was a collision. We've been clear. And the data has been clear. That has never changed. That data in the telestream system is based on a clock in the Lexus, which both sides know full well is different than a clock in an iPhone. You can see all the productions of Dr. Welcher's PowerPoint presentation where it shows that time, 12/31/43, has never changed. Also, it has been clear that both sides appreciate that there is a variance between the clock in the Lexus, which leads to that system information, and a clock in an iPhone. In fact, the defense was so aware of it, they hired an expert, Mr. DeSorga, who gave his opinions about that variance. We have never suggested there was not a variance in this case. In fact, variance. When their expert, Mr. DeSorga, provided a report, we believe that his analysis was wrong. And so we looked at the variance and the data that was available from the telestream system and John O'Keefe's Waze data that was on his phone that was always available to all of the experts in both sides. And when Mr. Burgess looked At the variance, at the time of a 3-point turn, about 7 minutes before the collision, he simply matched the Waze information on Mr. O'Keefe's phone to that of the information from the telestream, and saw that it was a 21 to 29 second variance. All that data was available to the defense because their expert made an improper conclusion is not our fault. This does not change the testimony of anybody. They point to Jen McCabe's text message where she said she thought she saw a motor vehicle out front that evening at 12:45. That is not consistent with the Commonwealth timeline, but that doesn't change. That favors the defense. It does not change anything to do with ARCA. ARCA has not, as far as I've seen in any reports, ever talked about the variance, just Mr. DeSorda. And so because this is inconvenient for the defense, and because it further focuses the variance that we already discussed and provided, isn't a reason to exclude it. It's not late discovery. It's not a Rule 14 violation. It is further analysis of information that was already provided, opinions that were already provided, and it is in response to their experts' mistake about that variance. There's nothing new here. Nothing has changed.
Go right ahead, Mr. Leslie. The only question I had for you yesterday, for you to respond to today, was the time. So I gave you more leeway.
And you're giving me more leeway, and I appreciate it.
Go right ahead.
So 2 items, Your Honor. As I alluded to yesterday, and it's been a point that Mr. Brennan just made. We believe strongly, Your Honor, that at a minimum there needs to be a voir dire of mistress. And we believe strongly there needs to be a voir dire because we have a serious concern that the sequestration order has been violated. He has changed a very key aspect of this matter after the testimony of Mr. Whiffen, after Mr. Whiffen presenting a timeline in his report, Mr. Burgess, his new purported report of May 8th. He references to align it with Mr. O'Keefe's cell phone. That is the essence of Mr. Whiffen's report, is anchoring in his timeline. He did a whole timeline on Mr. O'Keefe's report. And conveniently, the proposed alteration by Mr. Burgess in his report of this clock drift now makes it very, very close to fitting within Mr. Whiffen's timeline and the theory of the prosecution. At a minimum, we need a voir dire to ask Mr. Burgess, why did he do what he did? Another reason for the voir dire. Mr. Brennan yesterday said, we were surprised to get the report. That further makes great concern as to why Mr. Burgess did what he did. Lastly, Your Honor, with regard to Mr. Brennan's point, and he made it yesterday and I corrected it, he said it again today, that supposedly our witness, Mr. DeSogra, made an error and that we're trying to correct an error of Mr. DeSogra. That is incorrect, Your Honor. Again, Mr. DeSogra was responding to Mr. Burgess's report. Mr. DeSogra's report is entirely saying, okay, Mr. Burgess says this, and therefore the defense says this. Now Mr. Burgess is changing what he is saying. So it is completely incorrect to say that Mr. DeSogra is to correct an error. That would require, again, Mr. DeSogra. There was also an issue, Your Honor, and this is extremely important with regard to burden shifting. There's not only the question of should this be allowed at all, there's not only the question of how much. What Mr. Brennan proposed yesterday was a very irregular process where essentially the Commonwealth gets 3 bites at the apple for a problem that they caused. The problem we're talking about is Mr. Burgess changing a significant part of a timeline. Yes, there was a variance that he had, but he picked a range of the variance. He's now changing the variance. So what the Commonwealth is proposing is that our witnesses go forward, the aperture gets to wait, they come on, and then the aperture gets to come on yet again. We would urge.
I did not understand the Commonwealth asking me that. Are you asking me to do that, Mr. Brennan?
Appreciate the
I'm not
clarification.
sure what he's saying, so. I
It
don't
sounds
know
like
what you're talking about.
DeBrosia or whatever.
His name is DeSoto, yeah.
DeSoto,
You know,
you're suggesting that the Commonwealth suggested yesterday that he testifies first and then the aperture witnesses?
What I understood was going to happen.
That's what he
is
asked.
Mr. Brennan said yesterday that Dr. Welcher cannot come in until after.
No, I didn't understand that. I understood Dr. Welcher, Shannon Burgess, and then Dr. Welcher for everything that you folks received prior, January 31st, or whatever the date was. And then potentially for all the new ARCA information that came in May 7th, that portion, Dr. Welcher returning on rebuttal for. Not that they were holding back Dr. Welcher completely. Is that correct, Mr. Brennan?
That's the conversation I had. That conversation I wasn't part of.
Yeah, I think you misunderstood that, Mr. Alessi.
So I did, just so I'm clear, what is it that the rebuttal?
Mr. Brennan, all right, this is separate, and I'd really like to give everybody a break here. What is it the Commonwealth is asking to do regarding that?
Regarding Mr. Burgess or Mr. Welch?
It's Dr. Welcher.
Dr. Welcher should come in and testify to his PowerPoint, all of his opinions, which address all of the prior representations and opinions of ARCA, although we still don't have any raw information, but we're ready to move forward. Regarding any new opinions, which there is over a dozen new opinions that includes testing, video, experiments, Dr. Welcher should have enough time to review, conduct his own testing, turn it over, and then in rebuttal, address limited to the new issues raised by ARCA.
That's how I understood it, Mr. Alessi.
And that's how I did also, but the question is now with the Burgess changing of the clock drift, how many can talk about that? Is he just going to come in and talk about it?
So you talk with Mr. Brennan about that. All right, so I'm all set for this.
There are no changes. There is no changes in the timeline. He keeps trying to portray this as something has changed. Nothing has changed. It's the exact same.
he was surprised.
He's always said there's a variance. He's been looking into variance for a long time. And now he has found a method to show the exact variance. It's not changing. There's nothing in the reports that changes as far as the timeline. That's just an attempt to cause fear. There's nothing that has changed. We can look at the reports. It's all the same, always has been. Other than now he's identified the mistake of their expert, and that led him to be able to identify the variance, which is helpful and new. And the suggestion that there's been some violation of an order, no good faith basis whatsoever.
Does the Commonwealth oppose a voir dire just on that one issue?
Yes, because it's suggesting that there's a good faith basis for it. Nothing has, Ian Whiffin's report was available to the defense and our experts months and months and months ago. The issue of variance has been an ongoing issue for months. There's nothing that triggers a change in the testimony to adopt or adapt to it. Our timeline has been the same since when we turned it over at the beginning. They cannot point to one thing that has changed between Dr. Welcher, Ian Whiffin, Jessica Hyde, or Shannon Burgess. They are just saying things without a good faith basis. In the reports, show us where something has changed.
Your Honor, to inform you, Your Honor, we would like to print the page in the clock adjustment because what Mr. Brennan says is.
Yes,
correct.
and I'm happy to any information.
Thank you.
All right,
The change.
20 minutes.
No.
Thank you.
All rise for the court, please.
Well, let's see. She's only going to have time for one White Claw. Let her go. Okay, as I was saying, if I can find it again. Oh man. It's hard to read. I think Judy sent it to me. Let me check the mail. I might be able to read it better. If StreamYard will comply. Doesn't like to multitask. It's like a bratty toddler. It wants all the attention to itself. Yay! It didn't crash. We shouldn't have said that. Okay, let's just can read. Supplemental order regarding the buffer zone. The court is in recess of the State Court of Appeals for the First Circuit in Grant v. Trial Court of Commonwealth of Massachusetts. To simplify any potential First Amendment issues related to the buffer zone restrictions implemented by prior orders, this court, guided by the Court of Appeals suggestions set out on page 12 of the decision, issues the following supplemental order regarding the buffer zone. First, for all the reasons cited in support of prior orders and based upon the parameters of the dispute as narrowed and described in the decision, all orders of this court remain in place insofar as they apply to courthouse property. Second, prior orders remain in place as applied to pathways, including public sidewalks and roads, through which and at which times trial participants enter and exit the courthouse. Third, noisy protest, including those using amplified sound, honking horns, or loud screaming and yelling that are intended to interfere with the administration of justice or are intended to influence any judge, juror, witness, or court officer in the discharge of his or her duties are prohibited within the buffer zone. Fourth, the display of written or graphic materials that are intended to interfere with the administration of justice or are intended to influence any judge, juror, witness, or court officer in the discharge of their duties are prohibited within the buffer zone. Fifth, any person whose activity has been restricted by an officer enforcing this order may request review by a judge of the Superior Court, which request shall be heard as expeditiously as possible. Quiet off-site demonstrations on public property in areas and at times that do not interfere with trial participants' entrance into or exit from the courthouse and that do not interfere with the orderly administration of justice and the discharge of their duties are specifically outside the scope of the buffer zone restriction. So ordered. And it's signed by Beverly J. Canoni. You're right, it's vague, Judy. So they can't block pathways to the courthouse. They can't honk horns. They can't yell. They can't have any written. So they can't hold up any signs that have writing on them. I guess that includes shirts that have writing on them. I guess they can still wear pink if they want to, though. But it doesn't say anything about what size the buffer zone is. Is the buffer zone still 500 feet? Yeah, she made me open the door. At least it just cracked this time. Y'all don't want to look at my laundry room. I don't know if that's the same thing that Turtle Boy posted or not. I don't think that's the same thing Turtle Boy posted. His is really hard to read, though. I think this is different. It's just really hard to read. 2 weeks ago, attorney Mark Randazza and the Center for American Liberty filed a lawsuit in federal court asking the court to overrule Beverly Canoni's unconstitutional buffer zone. Judy Myong June decided to pass the buck, refusing to overrule Canoni. Randazza then appealed to the First Circuit Court of Appeals, who issued an order telling Judge June to come up with a way to make sure the buffer zone didn't violate the First Amendment rights of citizens. Oh yeah, this is different. It's just really hard to read. United States Court of Appeals for the First Circuit. Jason Grant, Allison Taggart, Lisa Peterson, Samantha Lyons, plaintiffs, appellants v. Trial Court of the Commonwealth of Massachusetts, Beverly J. Canoni in her official capacity as Justice of the Superior Court, Jeffrey D. Noble in his official capacity as Colonel of the Massachusetts State Police, Michael D'Entremont, and his official capacity as Chief of the Police Department of the town of Dedham, Massachusetts, Michael W. Morrissey in his official capacity as a Norfolk County District Attorney. Defendants appellates. Appeal from the United States District Court for the District of Massachusetts. The order, by contrast, seems to lack this is hard to read, a mens rea requirement, i.e., it likely applies equally to speech directed toward random passers-by and speech directed toward trial participants. And plaintiffs do not appear to ask us to allow them to engage in the latter type of speech. At oral argument, they indicated that they seek only to engage in quiet, off-site demonstration on public property, an area and times that do not interfere with trial participants' entrance into from the courthouse that do not interfere with the administration of justice and that will not influence any trial participants in the charges. These clarifications bring into focus plaintiff's argument that Cox's tailoring holding should not control this case. With plaintiff's position now clarified, we think it prudent to vacate but not reverse the district court's denial of a preliminary injunction and remand this case for further proceedings to determine how the order has been interpreted and applied, whether the amendment renders the order insufficiently tailored. Remanding a case for definition and examination afresh on an up-to-date factual record. Okay, that's clear as mud. As it stands, the state police are enforcing the order so that anyone who walks within the buffer zone is threatened with arrest. They already arrested a homeless man named Bayo who was not saying anything about Karen Reed, wasn't obstructing anyone's pathway, and was simply filming within the buffer zone. Media member Michael Bryant from Justice Served was told that he walked through the buffer zone too many times. John Delgado was forced to remove a button showing his support for Karen Reed. All of this has created a chilling effect that has scared people away from showing up to support Karen Reed at her second trial for murder. Last week, an organizer named Erica Walsh was told to remove a Microdots hoodie which says Criminals Control Norfolk County on the back. That has nothing to do with Karen Reed. And there's the picture of the hoodie. I like it. That sweatshirt says nothing about Karen Reed. More importantly, by wearing it, she is not influencing any jurors, obstructing anyone's pathway, or interfering with the trial in any way. Nevertheless, Erica was forced to remove the sweatshirt by Lieutenant Michael Hardman's goon squad. The problem is that underneath she had a Turtle Boy Journalism Isn't a Crime t-shirt, which they also said violated the buffer zone. She was forced by police to strip down to a sports bra and walk to her car in order to avoid arrest. No way. Absolutely not. Earlier this week, Erica was simply walking to her car with that sweatshirt on when she was threatened with arrest by Lieutenant Hardman and one of his troopers. She is suing. Good. She is now suing the state police in a lawsuit filed yesterday. The Massachusetts State Police has taken to using an unconstitutional order in the Karen Reed trial to force women to go nearly topless if their outerwear contains messaging they don't approve of. Superior Court Judge Cannoni pretextually shut down all First Amendment activity within the ill-defined buffer zone declared on the streets, public walkways, public library, and private property surrounding the Dedham Courthouse. Judge Cannoni entered the order ex parte, enjoining plaintiff and everyone else who are not subject to her jurisdiction from speaking on private property and on traditional public fora. It is lawless ultra vires act that violates constitutional guarantees of free speech and due process. Cannoni had no power to impose the buffer zone, and now the zone is being enforced in such a draconian manner that the Massachusetts... Where's the rest of it? I want to read the rest of it. Darn it. He didn't do the whole thing. Dang it, Turtle Boy. Crap. Well, you get the gist. I hope she wins. Threatening to arrest law-abiding citizens and making women strip down to a sports bra in public is horrifying and disgusting. Consequently, the First Circuit told Annie Bev that she had 48 hours to respond to their ruling, suggesting that she could also amend her order that it doesn't violate the First Amendment, or they could do it for her. Of course, the court could entirely of its own volition further simplify any potential First Amendment issues by amending the order to introduce a mens rea requirement, as in, this is like the same. I wish it was on the computer. I guess I could look it up and read it on the computer. Because he's got like different fonts. It's confusing. I need to look it up on the computer. It's like different fonts. It's like he's got like it's his commentary and then part of a document and then more of his commentary and more of a document. It's like different fonts, and so I'm confused. Here is what has changed. Supporters can now do what they did at the last trial. Pull up lawn chairs and sit in the grassy area by the church to watch the trial. Line the sidewalk to cheer on Karen Reed's team as they enter the courthouse, as long as they do not obstruct anyone's pathway. Sit across the street in the benches outside the registry of deeds as long as you want. Film anything you want inside the buffer zone, or anything you want inside or outside the buffer zone, so long as you are not attempting to interfere with the trial or influence a judge, juror, or witness. Anyone who is hassled by the state police inside the buffer zone for clothing they are wearing or other alleged violations can immediately request to be heard in front of a superior court judge. Basically, what you can't do is use megaphones or other noises that can be heard inside the courtroom, wear clothing that is intentionally designed to influence jurors or interfere with justice, block sidewalks that prevent trial participants from exiting or entering the courthouse. FKR supporters never did any of those things during the trial anyway. Only the Stamp 5 and the Smurf Patrol, who showed up after the trial, was overbrought noise amplifying devices. So basically, the old buffer zone, which was far less restrictive, is officially back. However, I'd take a picture of this order and have it on your phone to show police in case you get hassled down there. When asked for comment, Attorney Randazza issued the following statement. Judge Cannoni refused to be guided by her oath to uphold the Constitution, and the Supreme Judicial Court lacked the conscience as well. But fortunately, we had a federal appellate court that was willing to uphold and defend the Constitution as they swore to do. Now that Judge Cannoni has backed down, the First Amendment is restored in Dedham. It's a shame she didn't listen to reason when we tried to reason with her in the first place. I've donated $100 to the Center for American Liberty, who finance these lawsuits. And he's got a link where you can donate to if you want to. So Turtle Boy says, no, none of them were in all caps. Oh, she did ask them to arrest her? Somebody said, what chat was I in? Peter's, I think. And somebody said that Microdots knew John personally. I didn't know that. Turtle Boy said that it's back like it was last trial. Except for no like megaphones or anything like that. Nothing, you can't amplify your voice, so you can't do anything that would be heard inside the courthouse. Because I was going to say, I'd rather be arrested than have to walk half naked 500 feet, over 500 feet to my car. Because then I could turn around and, get a lawyer and sue their butt for false arrest. Because neither of those shirts said anything about Karen Reed. They were 2 shirts she bought from YouTubers that she watched. They nothing about Karen Reed on either one of those shirts. So that's false arrest. And so I would have let them arrest me and then turn around and sued their butt. But if she begged them to arrest her and they didn't, well, grounds for suing them. So yeah, I hope she wins. Yeah, they knew they didn't have grounds to arrest her. So I wouldn't have taken my clothes off. I would have said, no, I'll go to my car, but I'm not taking my clothes off. If you want me to take my clothes off, you're going to have to arrest me because I ain't going to do it. That's not right. That's just as bad as Proctor looked through from the news, making a woman unpublic. That's just good Lord. They're just like, is it just power going to their head? What? God. What is wrong with these people in Massachusetts? Do you think, I hate to ask this, but do you think there's any good, honest cops up there? I mean, what did they say? One rotten apple spoils a barrel? Because if you've got 1 or 2 honest cops that work with I don't know this, obviously, I don't know this from firsthand experience. I know this from watching TV. So it might not be a real thing. But on TV cop shows, when you've got like 1 or 2 honest cops in a group of cops that are crooked, you can't be the honest cop and tell on them because bad stuff happens to you. They set you up to fail. StreamYard, it keeps saying it lost connection to my audio right now. That reminds me of the O.J. Simpson trial. The supporters of Nicole Simpson Brown wore angels, like eagles and pins and stuff like that. And Marsha, wore an angel, and the defense objected to it. And so there was an order that nobody was allowed to wear an angel pin. So stupid. I mean, any jury with any sense knows that there's going to be people on both sides of the argument. They have to be naive if they don't believe that even serial killers have got somebody on their side. You know? Jurors would be stupid not to believe that someone believes that the person's innocent. And they know that they're not supposed to take that into account. So I don't see what the problem is. Lined up at the courthouse with signs or t-shirts or whatever, they're not supposed to pay attention to that. And yeah, I know we're all human and we can't help it, but I can't speak for anybody else, but myself, if I was a juror and I was to see a bunch of people lined up saying free whoever, and I heard the evidence and the evidence told me they did it, I wouldn't have a problem convicting them. Even if a million people were on the lawn saying free whoever, I'd say those people are crazy because this person did it. Maybe that's just me. I don't know. But I wonder if she made the comment to the jury about no comments. I think somebody said something about the stomach pictures yesterday. About how gross they were or something. I don't remember exactly what was said. That could be it. Or I don't think the jury made the a-hole comment, but maybe they made a comment about the a-hole comment. I don't know. But something had to have been said for her to say, don't make comments. But when something like that gets said, it just makes me want to know more. Like, don't pay attention to anything because that just makes me want to know more. It's like Wizard of Oz, right? Pay no attention to the man behind the curtain. It's like, what curtain? I didn't even know there was a curtain. There's a curtain. Oh, there's a man behind the curtain. It's like, why'd you even say anything? Now I see a curtain. There's a man behind it. It's like, don't tell me not to pay attention to something because that's exactly what I'll do. It's like the Streisand effect, right? Which is kind of like why they say that lawyers shouldn't object too much. Because if you object, then that's going to draw the jury's attention to it. They're going to be like, oh, they really don't want us to hear about that. I hate these long breaks. Is she going even longer because they had the hearing? I saw the cutest short this morning. And watch, I won't be able to find it again. Of course I can't find it again. Watch, I'll find it and then court will start again. Okay, all right, wait, no.
All right, so Mix Valera, I'm going to ask you that you speak right into your microphone when you answer, if you could, please.
Okay.
Thank you. All right, Sally, go right ahead.
We talked about sort of the
You guys, there's audio to court. StreamYard, you're killing me.
Did you do a physical match analysis between those two separate items?
May I? Yes.
And what, if any, conclusions you come to in relation to your physical match analysis between item 715 and item 760?
F and H. Fit mechanic.
Any conclusion were you able to draw with reference to the physical match between pieces from item 715 and pieces from item 716?
Those 4 pieces were at one time together as part of a larger unit.
Now, Ms. Valier, what physical match analysis did you do with reference to items 7-6 and 7-11?
B, fit mechanically with one piece from item 7-11, piece D. So those 2 pieces were at one time together as a larger unit.
And Ms. Valier, with reference to items 7-8, 7-9, and 7-16, what, if any, conclusions were you able to draw from any physical match analysis you did between pieces from those 3 items?
So 2 pieces from item 7-8, pieces C and D, 1 piece from item 7-9, piece A, and 1 piece from 7-16, piece E were found to have a mechanical fit. So those pieces were at one time together as a larger unit.
Lastly, for this section, at some point did you do a physical match analysis for the glass pieces in items 7-12 and 7-14?
Yes.
And what conclusions were you able to draw from your physical match analysis between 7-12 and 7-14?
There was no physical match between the glass pieces from, or parent glass pieces from 7-12 and the glass piece from item 7-14.
Now, Ms. Valier, are you aware that there was an additional analysis that was done with respect to glass pieces and other glass pieces that you didn't examine in your analysis at your lab?
I know that there was other trace work done. I'm not sure exactly what the work was.
Okay. And do you know who performed that additional trace work?
Christina Hanley.
And who is she to you as far as in reference to your work at the lab?
She's my supervisor.
Now, with regard to each of these items individually, they came as labeled in individual bags as we demonstrated on the screen, correct?
Yes.
And with respect to those bags, did you note any particular date associated on the front of those bags?
That's documented in my photos.
And all I'm asking here is that with respect to each of those bags of items, whether they be 3-1, 7-4, 7-5 or 6 or 8, many of those bags had different dates on them, correct?
Yes.
Okay. And when you received those items in that bag, you essentially removed the items from those individual bags, placed them on the table, and examined them, correct?
Yes.
And that examination included a microscopic examination?
Yes.
Now, with respect to any of those items, there were some items that pieces within the same bag that had the same date on that bag did not fit together mechanically, correct?
Yes.
However, there were items from one bag collected on one day that did fit mechanically with items from another bag collected on another date. Is that correct?
Yes.
Now, if I could turn your attention to item 3-1. Again, for the jury, what is the physical description associated with item 3-1?
Item passenger side taillight, Massachusetts 3GC684.
Now, did you perform a physical match analysis with pieces from item 3-1, 7-5, 7-6, 7-8, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, and 7-16?
I compared them, yes.
And what, if any, conclusions did you come to from your analysis, your physical match analysis between item 3-1 and all of the items beginning with the number 7?
There was a physical match with, do you want me to list?
If you
all
could,
of them?
please.
Okay. So 2 pieces from item 7-5, 4 pieces from item 7-8, 1 piece from item 7-10, 4 pieces from item 7-11, 2 pieces from item 7-12, 2 pieces from item 7-13, 4 pieces from item 7-15, and 4 pieces from item 7-16 were found to fit mechanically with item 3-1.
And what, if any, conclusions were you then able to draw from your physical match analysis between item 3-1 and each of those respective items beginning with the number 7?
Those pieces were once together as part of a larger unit.
May I approach?
Yes.
Mayor, I'm showing you 3 additional photographs. Do you recognize what's depicted in those?
I do.
And what do you recognize those?
This is a comparison between item 3-1 and those pieces from all of the other pieces.
Your Honor, Commonwealth, I seek to introduce and admit as the next exhibit A, B, and C.
Is there any objections, do you know?
No objection, Your Honor. Thank you.
182, A and C.
And may I publish, Your Honor?
Yes.
Ms. Gilman, if I could have photograph 2096. Ms. Gilman, yes. If you could even zoom in just a little bit more on the item itself. Ms. Villiers, what are we looking at in this photograph?
So those pieces that I labeled from item 7 all of those, they all fit together mechanically into this piece.
And as far as earlier, you were testifying as far as the label maker and the different various pieces that you would label throughout the process of your physical match analysis. Do you see these in this photograph as well?
I do.
And where are they located with reference to the reconstructed piece above?
They're those little white rectangles on the piece.
So what's depicted here is the mechanical fit between items 7-5, 7-6, 7-8, 7-10, 7-11, 7-12, 7-13, 7-14, 7-15, and 7-16, correct?
Not items 7-8 and 7-14, but the other ones, yes.
And why not those two?
They didn't fit mechanically with the other pieces.
Ms. Gilman, if I could have 2150. Again, if you could just zoom in a little. And Ms. Valier, what are we looking at in this photograph?
So on the right side was that piece that was just shown. And on the left side is item 3-1.
And lastly, Ms. Gilman, if we could have 2151. Again, if you could zoom in on that item just a little. And Ms. Valier, what are we looking at in this photograph?
So that's that right piece on top of the taillight from the previous photo.
And is this the mechanical fit that you were testifying about earlier with reference to item 3-1, the taillight housing, and all of the various pieces that were found in 34 Fairview, starting with the number 7?
Yes.
Thank you. Ms. Gilman, you can take that down. Ms. Valier, lastly, in reference, did you also receive some debris from John O'Keefe's clothing?
Yes.
And Mr. Officer, we can have the lights back on. Thank you very much. And what did you find contained within that debris from John O'Keefe's clothing?
So it was 5 different items. So it was debris collected from, labeled as coming from the clothing. There was
Are there any pieces of apparent plastic contained within the debris?
yes.
Was there dirt contained within the debris?
Yes.
And that debris was labeled as an item 17-18.18. Is that correct?
I believe so.
And what is it that you did with the debris from the gray long sleeve shirt and the orange t-shirt?
So those were all packaged in like glassine folds. And I looked through it and documented it.
When you say you documented it, did you look at it under a microscope?
Yes.
So you did an examination under a microscope, is that correct?
Yes.
And did you measure some of those items contained within the debris?
Yes.
Specifically, did you measure items of apparent clear plastic contained within the debris?
Yes.
And what did you measure those items to be?
The piece of clear apparent plastic was approximately 1/8 inch by 1/16 inch.
And once you had conducted your preliminary analysis of those items, where did those items go?
I did no further examination on this myself. Christina Hanley might have examined some of these further.
Thank you. I have nothing further.
Giannetti?
Thank you very much.
Good afternoon.
Good afternoon.
I'd like to first talk fairly briefly about your reconstruction of the taillight to which you've testified. At the outset, by the way, that was item 7-3.1, am I correct?
Sorry, for which one?
That's the tail light, this 7-3.1, am I correct?
3-1, I believe.
7-3-1?
The tail light is item 3-1.
Oh, 3-1. I'm so sorry. Okay. With regard to that particular item, your lab has different departments, correct? Criminalists who do different things, correct?
Yes.
You are aware that there are scientists within your lab who do DNA analysis, for instance, correct?
Yeah. Yes.
And with regard to the order of processing items, is the DNA analysis done before or after you get the item?
It's usually before.
Okay. In this case, it was before. Am I correct?
I believe so.
Were you made aware that there were 3 contributors of DNA to that taillight, 3-1?
Were you made aware?
No.
Once you reconstructed the taillight, you'll agree with me that it was missing a piece, correct? Or pieces?
There was an empty spot on the overall reconstruction, yes.
Were you ever provided with any pieces of taillight that would have filled in that missing spot?
No.
Were you ever provided or told about any pieces recovered from 1 Meadows Ave in Canton?
No.
Were you ever told about a collision at 1 Meadows Ave in Canton? In any case, you'll agree with me, there was no glass in that taillight at all, correct?
Within the taillight, I classified them as apparent plastic pieces.
There's no glass as part of the taillight, correct?
I mean, it depends on what you call, like, the bulbs usually have glass as far as I'm aware.
Those are very, very thin glass though, correct? Those bulbs?
Yes.
All right. Now, your lab received clothing in connection with this case. You've testified to that, correct?
I received the debris labeled as coming from the clothing. I never saw the clothing at all.
Right, but you're aware that your lab received clothing before the debris got to you, correct?
Yes.
And your understanding was that that was John O'Keefe's clothing in which he was found on January 29th of 2022, correct?
It's labeled as coming from him. I'm not sure of the date that it was found.
Okay. You understand the procedure of that goes on at your lab when it receives evidence?
Yes.
And you know that once clothing is brought to your lab, it's given evidence numbers, correct?
Yes.
And then one of your colleagues at the lab handled the clothing and or examined it, correct, before it came to you?
Yes.
And your understanding is that one of your colleagues retrieved debris from those items of clothing and then packaged it in a fold before it got to you, correct?
Yes.
You then open up the fold and you look at the debris, correct?
Yes.
You never saw that debris inside the clothing, correct?
Correct.
And the pieces of clothing that come in are given evidence numbers when your lab receives them, correct?
StreamYard, knock it off. StreamYard, stop it! You're gonna make me mad in a minute now. I was having a good day. No, you didn't.
have that with you now next week?
I do.
All right, go ahead, Mr. Neely.
Having reviewed your reports, who it was that brought this evidence into the lab?
So you can tell us.
Okay. So submission 7, all the items that are 7 dash was submitted by Trooper Michael Proctor.
Were you aware of the date of the incident that gave rise to this case?
Yes.
And what was that date?
January 29th, 2022.
Seized from the Good Samaritan Hospital that very day?
No.
What date was the clothing brought to your lab?
March 14th, 2022.
So that means that your chain of custody at the lab began on March 14th of 2022, correct?
Yes.
And would you agree with me that was about 6 weeks after the date of the incident, January 29th of 2022?
Yes.
And of course, you can't speak to the chain of custody from January 29th to March 14th of 2022, correct?
Correct.
And you have no information and do not know why Michael Proctor waited 6 weeks. Do you know where Michael Proctor stored this clothing during that 6-week period?
No.
Do you know how often he was alone with access to the clothing during that 6-week period? Do you know if he had access to pieces of red or clear taillight?
Jury heard it.
You were not present when the clothing was seized, correct?
Correct.
You did not have custody of this clothing from January 29th of 2022 to March 14th of 2022, correct?
Correct.
You do not know what was done with the clothing before it arrived at your lab, correct?
You've covered this, Mr. Neely. Move on, please.
One last question.
There wasn't an
You
objection.
cannot
was there?
vouch for how the clothing or taillight pieces were handled before they got to your lab, correct?
Mr. Blair, there is a separate evidence unit contained within the Massachusetts State Police. Absolutely nothing to do with that, correct?
I'm not a part of that unit.
And so your responsibility as far as this, and then when you return the item to the evidence unit, correct?
Correct.
And from that analysis that you're running with the number housing from the defendant's vehicle, correct?
If it's 10 items, I don't have, I can count them.
Oh. As far as all those items beginning with 7 that you went further, and then to the taillight housing in 3-1.
The pieces that were previously stated, yes.
Nothing further.
All right. Mr. Neely, you are all set. All right. So jurors, that is it for track. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be extra careful with your social media use. And also, I just want to remind you, next week, Thursday is a half day and Friday is a day off. All right, so we'll see you on Monday.
Please rise for the jury.
Well, Judy, you don't have to worry about it. But let's wait just to be sure. If I'd known this, we could have done full specter this morning.
You may be seated.
Okay. So before we recess, I appreciate the council provided me with the information. Mr. Incorporated and with the Commonwealth had given me a few minutes before, but I appreciate that it was pointed out here. We've had full argument on this yesterday and today. My findings for the record are that the defendant has not persuaded me of undue surprise or unfair prejudice by this information, and I don't find that there's delayed disclosure. Of course, all of this is ample game for cross-examination, certainly as to what Mr. Burgess knew, what he looked at, why he looked at it, when he looked at it, why he changed his report, and violation of the sequestration order is all for cross-examination, and I will give you a lot of Mr. Alessi, I can tell you, obviously, you've got a great facility for cross-examining on the underlying information here. You've done fulsome cross-examinations. I have every confidence you can do it here again. But if after the direct, you demonstrate that you need further time, I'll certainly hear you on that. And more importantly, perhaps, if you feel that the testimony of Jen McCabe and the others that you've mentioned is critical and that you need to recall them, I'll hear you on that as well. So regarding Dr. Welcher, as my understanding, the request sidebar, and I found that it wasn't the right time. Let's see how much Dr. Welcher could go through. I understand Dr. Welcher will testify in the Commonwealth's case in chief next week or so, Mr. Brennan.
Hopefully next week, if not,
All right.
the day after the holiday.
And that will be for all of the material that was provided to the defendant initially, right, by the Commonwealth's discovery deadline?
Correct.
And what you're asking for is that after ARCA testifies the new information, you're asking for rebuttal, right?
Yes, limited to the new information.
All right, so I would allow under these circumstances a limited rebuttal, and we can define the scope after we hear the testimony of ARCA. So those are my rulings. Your objections were noted. I'll see everybody on Monday.
All rise for the court, please.
Okay, guys. I guess that's it. I am going to go take a nap. I will see you guys Monday morning. We will do Phil Spector, and then we will do this. And then I guess Friday we can do Phil Spector for a longer amount of time, since there won't be any Kieran Reed on Friday. And then on Saturday, my cousin has rheumatoid arthritis and fibromyalgia. And I have fibromyalgia and osteoarthritis. So we're both, we understand and we don't get upset about it, but we are both right now, we're theme park junkies. We were raised on Disney World, literally. Like, her dad was an engineer, and his boss left his job and went to work. Disney World has an underground city, literally. They call it an underground city. Underneath Disney World, that's where the magic happens. That's what runs all the rides and the animatronics and all that stuff. So his former boss went to work there. So we got in free. So we went at least once a year, usually twice a year when I was a kid. And so we grew up on Disney. Like that was like that's our happy place. So we are right now jonesing so bad we can't stand it because we've both been sick and haven't been able to go. And her right now she needs back surgery. So she was supposed to have back surgery, then her insurance refused it, and she can hardly walk right now, so she can't go anywhere. And we were gonna go to SeaWorld. She wanted to ride roller coasters. I'm like, are you sure you want to go to SeaWorld? You're supposed to have back surgery. So we've decided we're gonna go to City Walk, which that was a plan. I don't know if you remember, like a month or two ago, I told you guys I'm going to City Walk. I'm gonna make a video for you guys, and then it didn't happen. That is the plan. A week from tomorrow. So I'm gonna try it again. I'm gonna make a video for you guys if it happens. I don't know. I'm just so excited. I need to go somewhere, y'all. I'm so bored. Just sitting around the house all the time. I'm so bored. The plan for tomorrow, it's date. Saturday is like our date day, and we haven't done it in a while. We're supposed to go out for steak dinner, and he's gonna buy me yarn. I just need to go somewhere. I like my house, but sometimes it just gets boring here. I need a change of scenery. You guys keep me sane, and I'm not really sane, but you guys keep me almost sane. Oh, I love you guys so much. I don't really want to go, but we don't have any more trial to watch. So have a great weekend, guys. I will see you Monday morning for Phil Spector. And remember, be kind to people, love your family. Jesus loves you, and so do I. Bye, guys.